Appeal is allowed. Appeal is allowed, and the sentence hereby is set aside. Appeal is allowed accordingly. And jail inquiry will be accordingly informed for his release.
Outline.
My lord, I have the instructions, my lord.
Just a moment. After. Yes.
My lord, I have received the instructions, my lord. What the contract is saying, that this will take some time. Inquiries going on the allegations. Basically, my lord, will remember this case is against for the cancellation of the LPCs and allotment orders given under the reserve forest. My lord, if my lord,
Yes.
my lord,
Yes.
before this honorable court proceeds further, my lord, I would like to raise maintainability of the PI on 3 grounds.
It is undoubtedly maintainable. It is not an adversarial litigation, Mr.
Yes, ma'am.
See, we can't, you have to indicate.
Yes, ma'am.
You require.
Yes, my lord. If my lord forbids,
approximately how much of time?
my lord, that's for that, my lord. Only 3 grounds on the maintainability first. Second, maintainability on the ground that it is the subject matter of NGT.
If you raise the maintainability at this stage, we'll issue notice. We'll direct you to file an affidavit.
My lord, therefore.
What how this is not maintainable? You have invited some people to stay in the reserve forest area, and when the citizen is pointing out before this court, you are setting a technical plea that
my lord, no, my
it is not maintainable. The person against whom the LPC has been issued is not made a party. We'll take care of that part.
No, my lord.
But
not only that,
but you can't say that.
My lord, suppression of material facts, the petitioners have already gone to the NGT. The NGT has already passed an order.
Where is that? Okay, all right. You file affidavit.
No, my lord.
No, no,
Here,
you file affidavit to the extent that what is the stage of the
but
inquiry?
NGT has already
No, no,
disclosed.
just a moment. What is the stage of the inquiry? And approximately how much time it will take to complete the inquiry, at least from your side?
Yes, my lord.
We can't leave it at that,
Yes, ma'am.
inquiry is going on. We don't know when it will be completed.
My lord, therefore, my lord, what I'm trying. my lord,
And whether the NGT can go into the legality of the LPC,
it's-
that will also will
Yes,
examine.
yes, my lord. What? I'll just show, my lord. Why? This petitioner has already approached the NGT. NGT has passed an order because government has taken the stand that we have made forward the proposal for de-reservation. And NGT has,
De-reservation.
yes, my lord.
Now you want to de-reserve it.
Yes, my lord. Why, my lord? The entire Namsai area. It falls under the reserve forest, my lord. That way back in 1936, this was reserve, my lord. And already settlements are there. Now in 1980,
Yes, yes.
my lord would kindly see who are the petitioner. My lord, petitioner number 1 in the NGT. I'll take your lordship to their representation, my lord. One of their representation at page 245 also, my lord. There are several representations. Any of the representations.
Anyway, we will notice. Had Mr. Agassi,
My lord, what?
the council for, yes. You raise your maintainability at the admission stage, you filed affidavit.
Yes, my lord. Here, my lord, if my lord sees the Forest Conservation Act, there is a specific direction, my lord. Section.
We'll examine all aspects.
My lord may then issue notice on the maintainability. At this stage,
Maintainability can be raised at the stage of admission hearing.
my lord,
We are at this stage, we are
my
issuing
lord, I
notice.
have on prima facie, these petitioners, they have already approached the NGT.
You point out that.
My lord, I have submitted. My lord will see.
No, you file an affidavit. We have come across government advocate making, we have come across government taking a contradictory stand in a similar case, and the learned government advocate making a submission contradicting the earlier submissions made. Judgment is on the way. You file it on the affidavit. Yes.
But here,
Mr. A.K. Singh, learned counsel for the petitioner. Mr. Ed Merton, learned additional advocate general for the no, before that, M. Carter, learned DSGY for the Union of India, representing respondent number 1. One only. Yes. Mr. M. Ratan, learned additional advocate general for the respondents 1 to 9.
2 to 9.
2 to 9. Pursuant to order of this court dated 17/7/2023, Mr. Ratan London, Additional Advocate General, had produced a letter dated 21/3/2023, written to the Conservator of Forest HQ, Office of the PCC Veterinary, Government of Arunachal Pradesh, by the Chief Conservator of Forest, Eastern Circle, Tezu, whereby various proposals have been put up to look into the complaint regarding issuance of LPCs, NOCs in reserve forests under Namsai Forest Division in the proceeding held on 24/7/2023. Also, as the letter produced by Mr. Ratan Lal AAG was of dated 21/3/2023, he was granted further 1 week time to receive the latest instruction from the respondent authorities. Fixing the case to be listed on 31/7/2023. Not also, on which date Mr. Ratan prayed for further time for production of the latest instruction from the department. For sure. And not also, and the case was directed to be listed on 7/8/2023. Also, today, in process thereof, Mr. Ratan has produced a letter written by the written to him by the CF means Conservative Forest Headquarters HQ, dated 4th August 2023, by number FOR 213/CONS/2023, wherever it has been informed that details submitted by the Chief Conservator of Forest, Eastern Arunachal Circle, Tezu, requests further examination, and the inquiry is still under progress. Also, in the apostle letter dated 4th August 2023, it has not been indicated in any manner that at what stage the inquiry is, and approximately how much time it would require for completion of the inquiry, as stated in the letter dated 4th August 2023. In view of the issue notice returnable in 4 weeks, and Mr. So-and-so has accepted notice on behalf of the respondent so-and-so, no formal notice is issued. Requisite extra copies of the petition be served upon the council for the parties. List it after 4 weeks.
Okay. My lord, no. Paper, sorry, records it appears have come, my lord.
Mr. D. Council for the appellant and Mr. G. Taro under APP. Office note dated 19/7/2020 indicates that the LCR has been received. In view of the registry shall prepare the paperwork and list it thereafter.
In three, actually, H. Lakshmi was endorsed in this case.
Yes.
She is vehicle problem, so she couldn't reach by time.
Who is for the appellant?
I do not have even brief also. Brief is with her.
No, none appears. List it after 2 weeks.
of it.
None appears for the parties.
Lordship bias for conditions delay. 79 days lordship. if a ground for delay has been stated in paragraph 2 of my application,
How many days of delay?
79 days was.
Yes. What is the objection?
Yes, I'm awarded this is condemnation application, my lord.
Huh?
And I know that this is a application condemnation, my lord. But then, my lord, I will only bring some back, my lord. This departmental inquiry, my lord, the even in the this the from which this case arose, my lord, it started in 2015, my lord. Now, till due to this departmental inquiry, my lord, I, my lord, yet to my lord get some benefit, my lord. Whereas my colleagues, my lord, has now in the mention this para also, my lord. If my lord start with this, put the regional grant for condonation with delay, my lord. In short, my lord, my humble submission, my lord, they are intentionally, my lord, depriving my right, my lord. So that my humble submission would be, well, taking into this application, my lord, look into my concern also, my lord. This read appeal, my lord. Also is, my lord, only one simple issue, my lord, whether, my lord, the dispute, title dispute, my lord, would can be a subject matter of the departmental inquiry, my lord.
If my friend has no objection in condoning the delay lawsuit, on merit lawsuit, it can be taken up tomorrow lawsuit on admission, and this I may be allowed.
I, my lord, my humble submission, my lord, this grant mentioned, my lord, would not be a
All
regional
right,
grant.
have Mr. S. Tabil Lalit, Senior Government Advocate for the applicant, and Mr. L. Parveen Lalit, counsel for the opposite party. This is an application under section 5 of the Limitation Act 1963. Seeking condonation of delay of 79 days in preparing the unit appeal number 16 FE of 2023. However, the order dated, judgment and order dated passed in WPC 205 FE of 2022. Dated 2/2/23 has been challenged. Full stop. The reason for delay of 79 days in preparing the collective appeal is stated to be on account of the legal opinion that was sought for from the prosecuting officer of the department. And thereafter, the time taken by the competent authority for approval of filing the connected read appeal. The opposite party has filed an objection opposing the application for condonation or delay, whereby it has been contended that the explanation given by the application in the accompanying application seeking condonation of delay of 7 days in preparing the connected read appeal is not a reasonable explanation requiring condonation of the delay of 79 days in preparing the connected read appeal. Full stop. Upon hearing the upon considering the explanation provided in the accompanying application, explaining the delay of 79 days in preparing the connected writ appeal, stating that it was on account of the legal opinion it was sought for from the prosecuting officer of the department, and thereafter the time taken by the competent authority for its approval for filing the connected writ appeal, and also having regard to the settled position of law laid down by the Honorable Supreme Court in a catenary of Mohitan, that the application filed under Section 9 of the Limitation Act has to be dealt with in a very liberal manner. We are inclined to allow this application seeking condonation of delay of 79 days in preparing the connected writ appeal in the interest of justice. So accordingly, the delay of 79 days in preparing the writ appeal number so and so is hereby condoned. I esteem allowed and disposed of. Yes,
If this appeal may be received tomorrow.
in view of the order passed today in IA 84 FA of 2023, let this appeal be listed for admission hearing after a week.
My humble sir,
Not tomorrow. If it is to be tomorrow, we'll take it up. Why tomorrow? Yes, what is the appeal about?
Lordship,
Yes, and on the obligation, we'll take it up.
yes,
Yeah.
Lordship. Kindly come to page Lordship 13, 13 Lordship. This is the interim order. Lordship. The petitioner is Lordship, he belongs to Lordship APBN Lordship. The past APBN. He's a constable there. Lordship. He encroached the Lordship, the lane of the Lordship APBN. He encroached over the lane of which
Okay.
has been the lane which has been allotted to APBN.
Ah.
His employer's Lordship, the lane has been encroached by him. This is a conduct Lordship.
Okay.
Here two aspects Lordship. One aspect Lordship, he encroached. Another Lordship, appropriate law he can be evicted. That's the one part.
sorry, my lord, I strongly object the word in cross, my lord. That is totally not my lord.
You have occupied.
I'm occupied, my lord. There is a civil dispute, my lord, and prima facie, my lord. I am the owner, my lord. The government have even give a compensation while constructing the road also, my lord.
Let us see, let us see.
So, sir, can it be taken up tomorrow? Lordship?
After a week.
That was my concern, my lord, in the white litigation, my lord.
What?
Their intention, my lord, is to delay somewhere to delay, my lord.
What is the difficulty? Yes, what is the case
Just,
about?
I didn't bring.
Okay, whether it is encroached or occupied,
No.
okay. He is into the land of APPBN.
No.
Okay, then what happened? Then department proceeding was drawn up for misconduct.
Misconduct.
Okay, then
Then Lordship, against that particular Lordship, department inquiry order Lordship, he can be put strong for Lordship.
against that department proceeding.
Yes,
Okay. Department proceeding was at which stage?
it was already concluded.
Already
Yes,
concluded.
against that order, he can be put strong.
Penalty imposed.
Imposed Lordship.
Minor.
Yes,
What kind of penalty?
that Lordship, if Lordship say the first judgment Lordship, it pays 2/6 Lordship.
No. Department proceeding was concluded.
Lordship,
Minor penalty imposed.
imposed Lordship.
What kind of
Reduction of 4 Lordship increment.
okay, reduction of 4 increment.
Lordship.
Did he prefer an appeal
Lordship, against that order, he can be put strong.
without preferring an appeal?
Yes, Lordship.
Then this court entertained it.
Lordship.
Yes. Yes.
That order is in page 26. Lordship.
Page 26. Yes.
Relevant is Lordship page 18. Lordship.
Page,
Page 18. Page
you said 26,
lawsuit. Sorry, I'm lawsuit. This is page
28, I think, relevant.
20.
28, yeah.
A reading of memorandum of charge and the article of accusation and the statements of imputations go to show that the charge against the petitioner is that he is unauthorizedly occupying some government land. We put a query to the learned counsel for the respondent as to in what manner a person unauthorizedly occupying a plot of government land would commit a misconduct in his service. Given is the petitioner belongs to a disciplined force, unauthorizedly occupying a plot of government land is an act of indiscipline, and therefore the petitioner was appropriately charged. No doubt the act of the unauthorizedly occupying a plot of government land would be an illegal act which provides for its own procedure under the law. In what manner it has to be done. Such be an act of misconduct requires some further deliberations on the aspect. The Honorable Court also has not come to a conclusion. From the said point of view, we interfere with the said orders. That is so and so. This is the order by which lawsuit the action was taken against the petitioner, by which the punishment of withholding of 2 increment was imposed on the petitioner. The consequential appellate so and so stands interfere.
He appears to
I'm
yeah.
sorry. The matter is remanded back to the disciplinary authority to consider appraise whether the unauthorizedly occupying a government land, a plot of government land, also amounts to misconduct and indiscipline in service law. Depending on the conclusion that may arrive at, a written order be passed by the disciplinary authority. However, as it has been brought to the notice that the petitioner is unauthorizedly occupying a plot of government land, the liberty would also remain on the respondent authority to proceed with the petition as per law with regard to illegal occupations of a plot of government land. This is how lawsuit this Honorable Court remanded back the matter, giving liberty to take a press lawsuit, action lawsuit. Accordingly, lawsuit decision and against that order lawsuit. Kindly come to the impugn order and writ petition. It is a page 31 lawsuit.
30, yes.
Here lawsuit will find at page 32 lawsuit. I'm taking lawsuit to down below. Therefore, page 32 lawsuit. Therefore, in compliance with the aforesaid court order, following orders are passed. The act of unauthorizedly occupying a plot of government land by Lensnaya Tai Tache of first AFPBN, which is under positions of the commandant first AFPBN since 1989, as per the government allotment order number so and so, that is so and so, amounts to misconduct under section 6 rule 211 of CCS conduct rules. And then second lawsuit. The pertinent is lawsuit here lawsuit is refer lawsuit section 6 rule 211 of CCS conduct rules lawsuit. Now I'm taking lawsuit to the present impugn order lawsuit. It page lawsuit 1313 lawsuit. Page 13 lawsuit. 1313 lawsuit.
13.
13 lawsuit. 1313. And relevant is at page 15 lawsuit.
Yes.
Paragraph 6 lawsuit.
Yes.
I have considered the submissions of both the learned counsels. A person cannot be held guilty of having committed an offense which does not exist. It is admitted fact that the section 6 rule 2 of CCS conduct rules does not exist. For that reason, the charge against the accused cannot stand. Since the charge has no basis, the punishment or sentence given against the petitioner also cannot stay because it would have no basis to stand. Here, lawsuit, so far this section 6 rule 2 is concerned lawsuit. It is not exist in the lawsuit CCS rules law. But this clarification has been given in our affidavit in opposition lawsuit. Affidavit in opposition is a paid lawsuit.
He was charged under which rule? For violation of which rule?
CCS rules.
Which particular
Here
provision?
lawsuit, this here for lawsuit, affidavit in opposition lawsuit.
Not the affidavit of opposition. In the departmental proceeding,
In departmental proceeding lawsuit,
yes.
here lawsuit in subordination lawsuit, because he was directed to vacate his illegally occupied land
In subordination.
in subordination. Is
Which
one.
which rule provides for that insubordination?
Therefore, lawsuit, here it says lawsuit, section 6 of CCS rules. lawsuit.
Hmm.
In that particular, this provision is not given there lawsuit. In CCS rules. lawsuit.
Which is the provision for insubordination?
Therefore, lawsuit in our affidavit in opposition, that clearly.
Not the affidavit of opposition. In the DP proceeding, you must have some charge it upon memorandum of charge upon the petitioner,
Lawsuit.
is not it? Now, he which provision of CCS rules?
Lawsuit, this is lawsuit, 32 lawsuit.
Page
Page
32.
32 lawsuit.
And he must have depended himself on the against the charge, memorandum of charge submitted, furnished to him.
Lawsuit.
We can't go as for the affidavit now. Huh? You can't explain through affidavit where you will improve upon your case.
No.
Yes,
I'm not, actually, therefore, lawsuit, I was praying for tomorrow lawsuit, because I have not gone through lawsuit, some of the.
yes,
documents.
memorandum of charge was submitted, some of you.
Yes.
Where is that?
If my lord kindly turn to page number 20, 20, man,
20,
20 of the
20,
my lord.
20.
My lord.
Yes. How many charges? 1, 2, 3.
Charges at page number 21, my lord. 21, man.
Yes. Read. How many charges frame?
Oh, sorry, my lord. This first charge I was exonerated, my lord. The second charge is at page number 40, my lord. This is
Second charge.
second charge, my lord.
Yes, sir. Where is the second charge?
Second charge, my lord. I think in my. At page number 77, my lord, in my read petition, my lord, that was page number 77. My lord. This is the second charge.
Page number 77.
7, annex number 3. My lord. I was initially I was charged with south of the 3, my lord, of dear land, my lord. That from I was exonerated, my lord. Initially, my lord, I was charged under my lord unauthorizedly selling of the 3, my lord, of the this respondent, my lord. This charge, my lord, department inquiry is done, my lord. I was exonerated, my lord. Accordingly, my lord, order was passed, my lord. I should be again put under inquiry to this, my lord, 17 November 2016, man. This is the second charge, my lord. The substantive review of this music on claiming government land, my lord. This is the only charge, my lord. Claiming of the government land, my lord.
This is not a memorandum of charge.
This is the my 2016 annex number 3, my lord. Memorandum of charge, my lord. Article of charge, my lord, by next 78, my lord.
Okay.
Page 78.
78, my lord.
78. How many charges?
For my lord, past my lord, statement negligence of duty, misconduct in support of the article of such.
Okay, Article 2, Article 2.
Two charges.
Two charges.
Two, my lord.
First is what? First is what?
Statement imputation of
You may
duty.
read claiming a plot of land located in between RP Gate and NS 52, which is under the possession of first APBS as described as per described map and government allotted motion is amounts to. Okay, first charge is your claim of on a plot of land located in between RP Gate and NS 52, which is under the possession of first APBN. It amounts to misconduct. Okay. Then second is
Same, my lord.
claiming
Allegation
and illegally trying to grab a plot of land located in between RP Gate and which is under the possession of as well. Amounts to gross misconduct stroke indiscipline. There is no question of insubordination, Mr. Tape. He has been charged for gross misconduct and indiscipline.
No.
Okay. Then what happened to this charge?
As my lord, I was one guilty, my lord, according the two increment, my lord, what withheld against me, my lord. That is at 8 page number 83, my lord.
53.
83, my lord, last part, my lord. Therefore, in the excess of person, I do hereby impose a penalty withholding two increment, my lord. Instant proof, my lord. Pay some any control. So
Some rule.
that para is will be relevant, my lord.
Okay.
According the inquiry officer, TUI Gamblin submit his report after conducting through inquiry into matter as per laid down for the department inquiry. Delinquent has been found to be given an opportunity to engage defense assistant. Enough opportunity has been found to given a delinquent produce defense documents as well to nominate the name of the defense given, but delinquent such and such failed to submit any concrete oral evidence which can substantiate his claim on the plot of land in between RP Gate and NS 52. Hence, search against proof, my lord, instant proof, my lord. Accordingly, my lord, last part of my lord, withholding of two increment, my lord, with cumulative effect, my lord, was passed against me, my lord.
Yes.
Against this, I prepare appeal, my lord. Appellate order, my lord, will appeal.
In exercise the power conferred in sub rule 2D of rules 3. What is that? Rule 2D of rule 3.
This is and this is the provision where, my lord, increment may withhold, my lord. This is part of punishment is prescribed, my lord.
Punishment for?
Withholding of increment, my lord. Specific provision.
For what? Indiscipline.
No, my lord, not in this, my lord. Under this, my lord, rule 3, my lord, what punishment can be given by the disciplinary is prescribed, my lord.
Okay, all right. This was challenged.
This is challenge, my lord. This were I appeal, my lord.
All right, this has been set aside.
No, my lord. A plate authority, my lord.
Affirm it.
Affirm partially affirm it, my lord.
Okay.
Page number 100 is the relevant part.
100?
Oh, sorry. Yes, affirm it, my lord. 100 page number 100 is the order part 100, my lord. By the appellate authority.
Then you challenge both the orders.
No, my lord, I feel the revision, my lord.
Okay, revision also affirm.
Revision, my lord, down the one increment was, my lord, down the my lord.
Okay.
Affirm the other one increment. Now I
Slight modification.
my,
Then you came to High Court.
my lord,
High Court set aside all orders.
all of them
Take a fresh decision.
take this and
And where is that decision?
decision, my lord,
Kapil has already pointed out.
pointed out. Now there is no such exist, my lord. My lord has correctly pointed out, my lord. They are trying to, my lord, improve, my lord, they are, my lord, ordered by the mean of submission in the through epidemic, my lord.
No, where is that
Page
order?
31.
Page 31. Okay, then what have they said in the affidavit?
Epidemic, they say, they submit my page number, P151 would be related. Is there, this the epidemic mail, 151 mail,
Huh?
151 mail.
In the affidavit filed in the writ petition, isn't it?
Yes, 151 mail.
151.
Now they try to rely on this 4-number mail, conduct rule mail,
151.
151, annex number 151 mail.
Yes.
Do's and do's not for my perfection. 4 maintaining a responsible and decent standard of conduct in private life. Now they try to rely, my lord, under this provision, my lord, I was had guilty, my lord.
In the affidavit, they said.
Yes, my lord. In the affidavit, they try to indicate their affidavit, my lord, is
Where, in which paragraph?
it, my lord, 146, my lord. 146. This is part of their affidavit, my lord. Oh, start from 145, my lord. Para 22. I am reading para 22, my lord. That we trigger statement made in favor of 15(1) of the petition. The answering deponent not admit and deny. It is submitted that in fact the commandant pass APP and slip while passing order that such and such rely on the clause 2 conduct and omission which amount to misconduct of chapter 6 conduct rule of Swami Handbook for General Government Staff. Motto Swami and Virenda. Yet inadvertently reflects section 6 from it. Now here also, my lord, they are saying clause 2 a conduct and omission, my lord.
This police department is its own estate officer also, I think.
Also.
Police department has its own estate
Yes.
officer also.
Yes.
So you can proceed against the petitioner through estate officer. Why this disciplinary?
Lordship, that part is already there, Lordship. But apart from that,
And just a moment. In the affidavit filed,
Lordship.
you have tried to explain that it is not the section mentioned therein, but it is do's and don'ts. Is it so?
Lordship, in page 145, Lordship,
145,
paragraph 22, Lordship,
22.
22, Lordship.
Yes.
Here, Lordship, we have explained, Lordship.
Hmm.
Section 6, Lordship, Section 6 rule to 11 of these conduct rules, which has been referred in the impugn order, Lordship. Impugn the order passed by the authority. Lordship. That has been mistakenly, Lordship, referred, Lordship. There is no provision as such, Lordship, where misconduct of an employee is given, Lordship. What we have explained is that, Lordship, page 145, The answering respondent not admitted and denied. It is submitted that in fact the commandant passed AAPBN Chimpu while passing order so and so, dated so and so, relied on clause 2 X conduct omission, which amounts to misconduct of chapter 6 conduct rules of Somi's handbook for central government staff, Mutusomi and Branda, yet inadvertently reflected section 6 to rule 2 of CC's conduct rules. Lordship, the authority used the Somi handbook, Lordship. This misconduct is referred in Lordship section 6 rule 2 of the Somi handbook, not of the CC's rule, Lordship. It is noted that the above acts and conduct which amounts to misconduct are envisaged in clause 23 of rule 3C of CC's conduct rules 1964 laws. Actually, it's given in this clause 22 of rule 3C of CC's conduct rules.
What is that? Let us see.
Lordship, page 153 Lordship.
153.
Lordship.
Yes.
This is the extract from the Somi handbook, Lordship. It's 23 Lordship. Acts and conduct which amount to misconduct. The act or conduct of a servant may amount to misconduct if the act or conduct is prejudicial or likely to be prejudicial to the interest of master or to the reputations of the master. If the act or conduct is inconsistent or incompatible with the due or peaceful discharge of his duty to his master. And so also.
No, which provision has been attracted in the instant case?
1 and Lordship, 1, 3 and 4 Lordship.
Where it is stated in the affidavit?
That is, here we talk about the 23 Lordship. This 23 Lordship.
This 23.
Lordship. No, this clause 23 Lordship. And all this misconduct, the list of misconducts Lordship, it comes under this clause 23 Lordship.
The inter provision of the clause 23.
Lordship,
No, where have you, so you saw it from the affidavit, not what you say.
in affidavit Lordship,
This,
we refer.
this is a matter of fact.
Correct.
You can't improve upon you
No,
as per your
I'm-
wishful thinking.
I am not improving.
Yes,
Lordship.
you pointed
Here
from the
Lordship, clause 23 has been referred in our affidavit Lordship.
clause 23 of rule 3C,
Lordship.
which is rule 3C.
Kindly come to page 153 Lordship.
Yes.
On top, Lordship will find rule 3C. On the top left hand side, Lordship. This is the part of rule 3C, Lordship. And clause 23.
Rule, you see what is rule 3C?
Rule 3C, Lordship.
You read. What is beyond rule 3C?
Lordship, therefore, Lordship, I didn't bring the book today, Lordship. So therefore,
No, this is your document. You can read it.
here,
What is
Lordship,
rule 3C? At page 153?
153, Lordship, rule 3C, prohibitions of sexual harassment of working women.
Then how it is relevant? Rule
Lordship,
3C?
Lordship, may I see the Lordship, otherwise, Lordship, misconduct prescribed in this particular clause. Lordship. This is the kind of, it's a general misconduct, Lordship, prescribed in the other provisions also.
next week. This can be disposed of at the admission stage itself.
That was only my concern, my lord. That way, my lord, my humble submission be, my lord, ultimately, my lord will look into the conduct of the appellant. Now, replay this DE started in 2015, my lord. Now, say equally for unreasonable return, my lord. I, my lord, deny some of my benefit under service, my lord. Now, issue here is they are saying, my lord, they have some improvised through epidemic, my lord.
No,
That-
are you in the occupation of some land or not?
Oh, my lord, for that, my lord, civil case is going on now.
Okay, no, according to you, even if you are in occupation of a government land, you cannot be proceeded departmentally. For that, other remedies are available.
Available.
That is your contention.
Additional
Will it not come under misconduct?
misconduct, my lord. Now, in addition to that, my lord, the law, my
If
lord,
a staff of a high court occupies a part of the plot of land of the high court, can he not be proceeded with departmentally for misconduct?
well, for that, my lord, they need to prove that this is high court land, my lord. Whether this is high court lane or not, my lord, that title itself is disputed, my lord.
In the departmental proceeding,
My lord.
you did not contest, is
I
not it?
I contest, my lord. I contest, my lord.
Let us see. Page number.
Page number- Page number 83, my lord. In the order itself, my lord,
Page number
83, my lord.
83.
83, my lord. This is the order, my lord.
Yes, 83.
83, my lord. According inquiry,
You read the third paragraph?
yes, my lord. This report after conducting the inquiry matter as laid down procedure has found to be in case depends enough opportunity given to the delegate the court is depend document and name of depend if any, but
Where are you reading?
the para 3, my lord.
Para 3.
Enough opportunity has been given to the delinquent court is depends documents as well as to nominate the name of depends with them, if any. But the delinquent such as fail to submit any concrete matter. It not say I fail to submit only
Okay.
document or I participated matter.
Yes,
Only
you
they are saying,
You failed to submit any concrete document,
Yes,
document or oral evidence which can substantiate his claim on the plot of land located in between.
yeah.
So you could not prove that land belonged to you, whereas they had produced an allotment order that this land is of the APPBN.
No, my lord, that's why, my lord. Other on the merit also other aspect, my lord. There is a in the 2016 itself, my lord. There is a their application, my lord, for that land, my lord, for allotment, my lord. This land does not come under their allotted land, my lord. There is a application by the authority, my lord, respondent authority. To that extent, my lord, if my lord kindly affidavit or their own statement is there, my lord. If my lord kindly turn to page number 59, my lord.
Yes. What is the status of the land now?
Status, my lord, as there is a status order by the civil court, my lord, this is as it is, my lord.
Okay. Status quo in what? Title suit?
Yes, that is.
Who had filed title suit?
I mean,
What is the stage of the proceeding?
still is a final judgment, my lord.
Final judgment. Then we'll admit this read appeal.
No, my lord.
Is not it?
My humble submission.
We will give a thorough hearing.
My lord, my humble submission, that is the aspect of matter. Today, my lord,
We are not staying the, sorry, this judgment of the one single judge. We'll hear. And judgment of the judgment in the title suit may also be relevant here.
my lord, my humble submission.
If you lose the title suit, you will be found to be in occupation of government land.
Yes, my lord, that is other, my lord, my humble submission, my lord, to the port that, my lord, that other aspect, today, my lord, is hearing that legality and, my lord, this perversity of that is order for a single basis. Now, until and unless, my lord, the appellant, my lord, would point out anything, my lord, perversity in the order for a single, my lord, ultimately, listing of matter, my lord, after ultimate victim would be the I, my lord. My
Did the-
humble, that's why, my lord,
Did the government contest the title suit?
yes, my lord.
Okay.
So what's the your claiming the land?
My lord, that I pass it,
Civil suit? Or
Pardon?
what strength you're claiming?
my lord, I pass it from,
Purchase that?
yes, my lord, the real owner, my lord.
Who is the real owner?
Real owner, my lord, that also I have annexed, my lord, yeah. He is the,
So both from whom you had purchased the land as well as the department is a defendant there.
no, my lord, from where I purchased, my lord, he is, my lord, my witness, my lord.
Oh, yeah.
To that extent, about the other additional aspect, prima facie, my lord, while construction highway, my lord, I was even given compensation, my lord, by the government, my lord, for
That
that
is-
lane, my lord,
That is what they are saying. You have taken compensation
my lord.
compensation on the land of the APPBL. That is
No,
what they say.
no, my lord. Earlier,
I have
to
read
that
somewhere like this.
to that extent, my lord, I have was exonerated from that charge, my lord. They are saying I have saved the tree, sold the tree, my lord.
All right, you want admission hearing next week or will admit it?
My humble submission, my lord, other aspect of the matter, this is read, other aspect of the, until, if my lord, they need to point out the perversity of the order from the record, my lord. Now, my lord had a senior government advocate, my lord. What he is trying to do is, my lord, he is trying to improvise their affidavit, my lord. That cannot be allowed, my lord. They settle law, my lord. They need to stick on their affidavit, my lord. By way of submission, by way of additional affidavit, my lord, that cannot be allowed, my lord. So that ground alone, my lord, my humble submission, this repetition liable to dismiss.
See, then we may again send it back to the department to pass a fresh order as was directed by the Learned Single Judge in the earlier round of litigation. Because thereafter the order which the respondents have passed
Right.
is based on the provision which is non-existent.
Right.
So shall we send it again back?
Well, that will be amount to giving the benefit of to the wrongdoer, my lord, and victimize the person who has not committed wrong, my lord. That my in the single bench, my specifically people, as they fail to point out any provision, my lord, I was submitted, my lord, this departmental inquiry start
All
since
right.
2015.
All right, all right. In view of the order passed today in IA 84 AP of 2023 and on the prayer of Mr. S. Tapil and the senior government advocate for the appellant, listed after a week for admission hearing. Next week we'll dispose of.
Always.
Lordship, my plate.
Yes,
This is a criminal appeal file against judgment and order dated 11/11/2019, right? And then the appellant has been convicted for life with fine of 20,000.
section. Under
Section
section.
302.
There is eyewitness.
No eyewitness.
Mhm.
There is no eyewitness In fact, this conviction is based on 164 statement and then other corroboration of some other evidence, and then extrajudicial confessions as per the judgment. It says as per the extrajudicial confessions. Whereas, and then in this case, medicals also it doesn't support.
Support.
It doesn't support.
It doesn't
There is, it says the cause of death is also not known.
Hmm.
But then allegation is only the strangulation. That is one. And other, the conviction is based on is that some article was recovered, that is especially purse, on the basis of the oral statement of the accused. The investigation agency has recovered purse. That's how.
164 statement has been corroborated.
No, 161 not corroborated. In fact, in this
No,
case,
earlier you said it has been corroborated by some.
as per the conviction, as per the judgment, matter, as per the judgment. But then I don't agree on that, because 164 also the procedure has not been followed as per subsection 2 to 4. There is no signature of the appellant, no magistrate signature, and no question has been asked to the concerned appellant while getting the statement by the concerned magistrate. Because it's a mandatory under CRPC, the question, the pattern should be the questions, but it was not done. And then the concerned magistrate who has given the confession statement, he is also not before the court. No statement was taken from the concerned magistrate.
PP, you are ready with the case?
Yes, your lordship, regarding to the extrajudicial confession,
No. We'll hear you if you are ready.
actually, I've taken this brief today morning only, because yesterday was Sunday and day before was Saturday. Course list came on Saturday, and our peon kept our office room key. So regarding extra confession,
Peon, no, don't jump into that. Peon is not beyond your control. Peon is beyond your control.
yes, there is a extrajudicial confession, and
No, if you are ready, we'll proceed with the case.
yes, I'm ready. I can proceed.
Okay.
I will just take to the FIR first, madam.
Yes.
And in the FIR, nowhere mention of the accused. FIR in page 1. May I read the FIR?
Just a moment.
Yes.
Are you genuinely ready?
Yes, I'm ready.
Then why it was necessary for you to point out that you have received the paper book this morning because the cause this,
Preparing, I came early today morning.
but you are ready.
Yes, if your lordship is ready, I'm ready.
See, we will not do it today. Beginning is not very happy.
Okay, next.
Okay, after 2 weeks.
Obliged.
Right.
See, the role of the PP is very important.
Important.
Exactly.
Yes.
Obliged.
Pure justice. For pure justice.
Your Lordship, I would beg to mention item number 36 on behalf of petitioner advocate M. Bora, who is currently out of station. Therefore, Your Lordship, matter may be listed after 4 weeks.
36.
Yes, my lord.
You are making mention on whose behalf?
Of M. Bora, petitioner advocate M. Bora.
What is this matter about?
It's about termination order, Your Lordship.
Termination order.
Yes, your lordship.
Okay. On the prayer of Mr.
E. Payeng,
On behalf of Mrs. M. Bora.
E. Payeng, on behalf of
Mr.
Embora.
M. Bora. The counsel for the petitioner listed after 6 weeks.
Much obliged.
May I, my lord? My lord, I beg to mention item number 16 and 17.
Item number
16 and 17.
16 and 17.
My lord, I'm on behalf of leading counsel, Mr. Abhinav Kumar. My lord, he is supposed to come today, but he is unable to reach here because he is from Delhi. My lord, already consent has been taken from other side. This matter may be, my lord, fixed on 25th September 2023.
Why? Any urgency in the matter?
My lord, I am on instruction.
I am a petitioner in 16.
Yes.
So this matter since 2019. So the basic issue was that whether the Secretary Housing is a competent person to transfer the ownership of the land. That is the issue here. And subsequent the arbitration proceedings, there was an agreement between me and the petitioner, and the two agreement was there. There is arbitration clause that I have no issue.
Okay.
But regarding the petition, I think it need to be disposed of earlier.
Okay.
So this is 3-4 occasions they have already
Then
solved.
why this matter, why this has been listed with arbitration case?
Because subject matter is almost
Okay, because they have,
same plot of land.
then we posted on 25th September? So you said September or?
September 25th September.
Okay. But he is expressing urgency in the matter.
My lord, actually, leading counsel is requested to fix this matter on
Even
25th.
last two occasions.
Another leading counsel is making a mention that matter requires urgent resolution. So what to do?
My lord, I'm instructed that the consent has already been taken.
From him?
No, Mr. Ratan has asked me. So,
Who?
Ratan.
Ratan.
Yes.
Who is the leading counsel you said?
My lord, Abhinav Kumar.
In fact, I was appearing here. The leading counsel is Mr. Abhinav. He is from Delhi. He will be doing the case. So I have taken consent from him and Mr. Tafo also.
But he is objecting to.
If my friend can accommodate on 25th as a last chance.
Last chance.
25th September?
This is second time.
Okay. All right. Then we'll fix it on 25th September.
25th.
If Kalag agrees, we have no issue.
Pleadings are complete. It
Okay,
can
all
be
right.
fixed for hearing.
Yes.
On a mention made on behalf of Mr. Abhinav Chaudhary.
Abhinav Chaudhary.
My lord.
Team, you are in the case.
No, my lord.
You are also not there in the case. Ratan is for the respondent in WPC, huh?
Yes.
Okay, Mr. N. Ratan, learned counsel, who was appearing for one of the respondent.
Yes.
One of the respondent in WPC 80/2019, and for the petitioner in the arbitration petition 5 of 2022 has submitted that one Abhinav learned counsel from Delhi
Yes, ma'am.
would now be appearing in his place, for which he has prayed for listing of this matter on 25th of September 2023, to which Mr. Tarak, learned counsel for the petitioner in writ petition and the respondent in the arbitration petition, has agreed. So in view of the above, list these matters on 25th of September 2023 as paid
For hearing.
for hearing,
Yes, ma'am. Readings are.
readings for admission.
Admission.
My lord, I also beg to mention item number 27.
Yes,
My lord, I on behalf of leading counsel A Dar
20,
27, my lord.
27, yes.
I'm on behalf of leading counsel A Dar, who is respondent. So my lord, he instructed me to matter maybe adjourn for 3 weeks.
Have you informed the other side?
Consent has been, my lord, already taken.
Mato Kato,
Yes, my lord.
okay. On the prayer of Mr.
Timite, my lord.
T. Mite, learned counsel on behalf of Mr. A. Dar, learned counsel for the respondent, with the consent of Mr. M. Kato, learned DSGY, for the petition listed after 4 weeks.
Much obliged.
May, my lordship, I beg to mention item number 27. my lordship.
37.
Yes, this matter is listed after weekly.
What is the matter about?
Service matter.
What is service matter?
His
In-
2 years increment was withheld. ma'am.
Okay. On the prayer of Mr. K. Wangma, learned government advocate, with the consent of learned counsel for the petitioner listed after 4 weeks. Okay.
My please, Lordship. Lordship, mentioned for IA in writ petition number 193, AP/23.
Writ petition is listed today.
Yes, writ petition is listed in item number 34.
Item number 34. Yes,
So same may be picked up for today because
you, and then you have filed one IA.
yes,
When?
today,
Today.
yes,
You have got a petitioner
yes,
or the respondent?
petitioner.
Petitioner. What is that IA for?
IA is for modification and alteration of the stay order, interim stay order passed by this honorable court.
Then you appears to be appearing for the respondent. Your name?
In Kanu.
Okay. When did you file?
Today itself.
Today itself. Who is for the petitioner here?
Petition.
He's
See, Modi, see,
I'm the petitioner.
you're the petitioner.
Yes,
Why do you want a modification of the interim order passed?
because we have jointly filed a petition here, but one of the petitioners, he has been given relief by the private respondent. This is a matter of tender. The JJM, that NOC was supposed to given by the GPC, but earlier they denied. Later on, the order of this honorable court, they have given the NOC.
Okay, we'll post this matter next week to be listed along with your IA. All right. There's no urgency. There's no urgency.
Urgency actually, yes.
Interim order was passed.
Yes. So
And you
it
have
is-
already, you have also been given relief by the respondent.
Yes.
And what kind of modification you want?
We want to vacate that the persons we have, since we have filed jointly.
Hmm.
So one of them has been given relief.
All right,
So-
you can wait for a week. Huh? Or
Lordship, if possible today, it can be taken up as a last matter then.
okay, all right.
Much surprise.
Pay your lordship. Lordship, I beg to mention item number.
Hey, जब एडवोकेट लोग देता है ना उसको लेने के लिए जाओगा. Yes,
Lordship, I beg to mention item number 6, your lordship, on behalf of Mr. M. Chanda for
Huh?
R5, respondent number 5, Mr. M. Chanda.
item number.
Item number 6, your lordship.
Six.
Consent has been taken, your lordship. This matter may be listed up for weeks. Your lordship, since the consent for the respondent is from Guwahati, so a fixed date may be given, your lordship. This matter.
How
may-
much time?
After 4 weeks, this matter may be fixed on 11th of September, your lordship.
What is the matter? Abu? What is the matter? Abu?
This is regarding matter, there's no rules, guidelines framed for one of the particular post.
Huh?
There are no any rules or guidelines that is framed for appointment to a particular post, technical assistance. You are praying that
Or some rules will be placed.
some, at least some sort of.
You will allow? How much time?
Lordship, can it be on 11th of September?
Okay.
Fixed
11
date
September.
given.
On the prayer of Ms. N. Anju on behalf of Mr. M. Chanda, learned counsel for one of the respondent. With the consent of Mr. Deepami, learned counsel for the petitioner as well as Picha. And standing counsel for the RD listed on 11th of September.
Lordship, obliged.
My lord, since the parties have entered appearance except respondent number 5, my lord, short date notice may be kindly issued, my lord. In the meantime, we'll file 2 additional documents, my.
Hmm?
2 additional documents.
What has been filed?
Yeah.
What has been filed?
We are contemplating to file 2 additional documents, my.
Additional document.
Yes, my. One is there, but the one said by the petitioner is not legible, my lord. We have to make a typed copy out of it, my.
Why you did not file it with
Yeah,
the
might be,
petition?
he was out of station, my Delhi, my.
Huh?
He was at Delhi, my lord. The
He
petitioner.
was at Delhi.
Yes,
Who?
the president of this contractors association, my lord. Because he is in possession of these documents, my lord.
Then in his absence, you had filed a writ petition.
No, he was here, but these documents,
Documents were in Delhi.
no, my lord. It is here in Itanawar. But on our, my lord, advice, this necessity of this, my lord, documents was needed, my lord.
No, why it was not filed earlier? That is what I am asking.
My-
The court is asking the document which you propose to file now.
Yeah.
Why it was not filed along with the writ petition? The writ petition was filed the other day only.
Yes, my lord, one of the documents, my lord, it was available at that time also, but it is not legible, my lord. So we could not annex it, my. The registration certificate. my.
Filing of additional affidavit, you will have to additional documents, you will have to file application seeking leave of this court. You may have left out many other documents also. You will gradually file at your convenient date. Is not it? Some of the documents might be lying in Delhi also, at the Delhi resident of the petitioner.
No, my lord.
What for? See, there are a lot of issues which you need to take note of. We are not engaging ourselves today on this matter was
Last time, my lord, this 31st,
uh,
and you will not say this, he was instruction.
Oh, that page 33, that NIT.
Yes, all those
Yes,
things, my
yeah.
lord. My lord, I have obtained the instruction. I think other side also they are privy to these documents, my lord. My lord. It's the detailed instruction given by the executive engineer, my lord, the field officer.
What it says basically with regard to this NIT? Okay, NIT was so not.
No,
Okay.
my lord, as for modification, it is not required. The secondly, my lord, so far is line, my lord, that is the standard format, my lord, used by the department. When the amount, my lord, is more than 20 crores, my lord, so that part was not required. So they have strike off that line. My lord, if you lordship, we can come up with a detailed affidavit. So basically, that is the reason, my lord. Number one, why they have strike off, my lord, because the tender amount was high, and as per that local Batch Entrepreneur Act, my lord, so that part was not required. So accordingly, they have strike off, my lord. And so far, my lord, NIT, this NIT or paper publication concern, my lord, that is not required, my lord. Only the website portal, my lord, they have to give it, my lord. I think executive engineer has given details, my lord. How many bidders participated, everything. My lord. Page 2, my lord, you will find my non-publication in this paper, my lord, which there has been given.
And my lord, so nearly 100 crore, my lord, the eligibility criteria to participate in this bid was, my lord, that the contractor should be of class 1 AA category, my lord. But these two, the private response.
Now it's a double A or single A, my lord, is immaterial, my lord. After this amendment of the rules, my lord. This carries the same meaning, my lord.
That is why, my lord, they have struck provisions which are adverse to them, my lord, only to accommodate these two private respondents, because, my lord, they are of class 1A category, and the Arunachal Pradesh 2008 rule, my lord, it is mandatory that if the amount is above 50 crore, then the contractor has to be of class 1 AA category, my lord. And this is a 300 bedded hospital, my lord. There is a guideline pertaining to such hospital, my lord, under Indian Public Health Standard, my lord. They have in the initial stage itself, they had compromised everything, my lord. The even amount is undervalued, my lord. And the petitioners, my lord, has no intention to stall such important projects, my lord, but has been, my lord, curtailed.
Whose rightful participation?
Well, all the eligible bidders, my lord.
Are you eligible with that?
Yes, my lord.
How?
Because we are of class 1 double A category.
We,
Yes. The out of, my lord, 3 out of the all the petitioners, my lord. That is why the document relating to that, my lord, we are required to furnish, my lord. So short that may be kindly, my lord, given to document.
how you are eligible to participate?
Sorry, my lord.
How you are eligible to participate? How your participation right in the NIT has been deprived by the respondents?
Yes, my lord. By my lord, conducting everything, my lord, in a hush manner, my lord. As my lord, I submitted that day, my lord. The as per NIT, my lord, the last date of submission of original document was
Who can submit? Who can participate in the NIT as per the NIT?
as per NIT, my lord, class 1 double A contractors, my lord.
Where it is written?
In the NIT, my lord,
Yes.
NIT they have not mentioned, my lord, but the rule says, my lord, guideline says that if the amount is above 50 crore, then the participant has to be of class 1 double A category. And they have violated this. My respondent number 4 and 5, my lord. That is why they had to instruct of this provision express 33. Because as per, if it is applied, my lord, they are not eligible. These 2 private respondents.
This writ petition has been filed challenging the invitation for bids within bracket IFB dated 22/6/2023 issued by the Executive Engineer, Pasigat Division, PWD, AP, Pasigat, by number PA/CON-1-24/1131-1137 at page 33. Whereby online within bracket turnkey mode in 2 bid system within bracket technical and financial online tender, I said, online tender from eligible APST and non-APST contractors enlisted in APPWD and equivalent class of category of contractors registered with other enlistment authority has been invited for the work within inverted comma upgradation of Bakin Pertin General Hospital Pasigat to 300 bedded hospital in East Siang District AP inverted comma close. at an estimated cost of rupees 99.03 crore. Full stop. The petitioner is stated to be all Arunachal Registered Contractors Association by the registration number SR/ITA/4231 with its headquarters at Papunala Nahalagan under Papumpare district of Arunachal Pradesh. And is represented by its president. Post of. Since the online tender has been invited, since the online tender, as mentioned above, has been invited from the eligible APST and non-APST contractors enlisted in APPWD and equivalent class or category of contractors registered with other enlistment authority, comma, in the absence of the petitioner describing itself to be a contractor enlisted in APPW, describe itself as an eligible contractor enlisted in APPWD and equivalent class or category of contractors registered with other enlistment authority as mentioned in the IFB dated 22/6/2023. I am of the view that the petitioner in the instant, the petitioner of the instant writ petition is not an eligible contractor in terms of the IFB dated 22/6/2023 issued by so-and-so, by number so-and-so, poster. In that view of the matter, the petitioner lacks locus standi to file this writ petition
May I submit?
to challenge the IFB dated 22/6/2023 issued by so-and-so by the number so-and-so.
May I submit a few lines, my lord?
Writ petition accordingly stands dismissed for want of locus standi of the petitioner to challenge the IFB dated so-and-so issued by so-and-so. At the top, heard Mr. N. Pada, learned counsel for the petitioner, Mr. Aris Nabu, learned AAG
1, 2, and 3, madam.
1, 2, and 3. Who else?
If the case, she was from number 4.
Okay, your name?
RB Fukal.
RV Pukam, learned counsel for the respondent number 4, who has entered appearance by filing a caveat number so-and-so. Anybody else?
Respondent 5, my lord, this notice is not issued, my lord. So no one is representing, my lord.
No, no, we have not issued. Okay.
Then
May I plead, my lord?
Status quo order dated.
31st.
Sorry, the status quo order passed on 31/7/2023. Accordingly stands vacated. Yes,
My lord, instead of dismissing, my lord, since this is public interest involved, my lord, in this case, Pasigat, my lord, being centrally located to 7 districts, including, my lord, neighboring Dhemaji district of Assam, my lord. Instead of dismissing, my lord, this may be converted into a PIL, my lord, and notice may be issued, my lord.
this order the order which we have passed just now could have been passed on 31st/7/2023. But for this NIT, in the manner they have issued, this instruction was sought for.
Or my lord, observation may be kindly made, my lord, that at the later is the.
No, see, you are saying something that this repetition raises an issue of great public importance. So it should be converted into PI. This was your first submission.
Yes.
When you were drafting this repetition, does this point did not strike your mind?
No, we have mentioned also, my lord,
Huh?
that my lord, quality.
We'll discuss some other day. Given this, I think.
This is transparent posting. The petitioner is agreed by my lord. Impugn transparent order dated issued on my lord 24/7/2023, which is at page 18, my lord.
Page number.
18. My lord, by this impugn order, my lord. Although this order is dated 16 July 2023, my lord, it was issued on 24 July 2023. My lord, by this impugn order, my lord, this private response number 5, which is at serial number 1, was posted, transferred from my lord, EE, Office of the Chief Engineer and Chief Engineer, PHE and WST Itanagar, and posted to PHE and WS Division Drawing as EE, my lord, vice me, my lord.
Yes,
I am with serial number 2, my lord.
yes.
My lord, the ground for challenge of this, my lord, impugn order is here, my lord. My lord, this impugn order, impugn transfer and posting order is not a normal transfer and posting order. It was, my lord, issued at the instance of, my lord, your lord, my lord, issued by respondent number, private respondent number 4, my lord, which is 8 case.
Just a moment.
Yes, my lord.
How many years you have been in rowing?
My lord, in this August, I will be 3 years.
3 years. Then how can we
But my lord, this transfer order was not issued on, my lord, in the interest of public service, my lord, or, my lord, an administrative exigency, my lord. My lord, this was issued, my lord, at the instance of, my lord, your note of the MLA, my lord,
Where is that?
page 22, my lord. It's page 22, my lord. May I read, my lord? My lord, subject transfer and posting of year such and such EE Department of PH and WS Department is Executive Engineer Rowing Division, Lower Division Valley District. It is learned that the incumbent Executive Engineer Rowing Division has completed the normal tenure at the present place of posting. Therefore, I propose year such and such EE Design and Planning BSE and WS Department to be posted as EE Rowing Division for the larger public interest. Honorable Minister, PH and WS may kindly approve his transfer and posting at Rowing Division immediately as a very special case of top priority. On this instance, my lord, this impugn transfer and posting order has been issued by us. Well, although my lord, on the face of my lord, this impugn transfer and posting order, my lord, it was issued in the interest of public service, my lord. But my lord, the reason, my lord, which was executed this impugn transfer and posting order is at page 22, my lord. And my lord, this
private response number 4, my lord, is MLA, my lord, come, my lord, advisor to Home Minister RDMP, my lord. She has nothing to do with the Department of PH and WS, my lord, first point, my lord. And second, my lord, she is not a MLA of that constituency, my lord.
MLA,
That constituency, my royal constituency. She is from Dambuk, 42 Dambuk Assembly. Though, my lord, this they are from same district, my lord, but constituency is different, my lord.
yes, Mr. Ratan.
He has already completed his tenure. 2 years tenure is already complete, my lord.
But why have you done in this manner?
In the read petition, my lord, apart from stating that it has been initiated only on the basis of the UO not submitted by the respondent MLA.
Hmm.
However, any mala fide has not been alleged, my lord. There is nothing against him. Only his tenure is over, so a new incumbent was brought in.
No, but
Now,
should,
Mohammed
but
Masud
should you
Khair-
do it? Should you do it when MLA or minister writes, you were woken up by this letter? Is not it?
Normal,
See, there is no transfer and posting made, particularly of the engineers in the state of AP, without a note, put up by either an MLA or a minister. Is not it? It's not an isolated case.
yes, my
But
lord.
should you be doing that?
Of course, my lord, routine transfers are not being exercised, my lord.
Ah.
But in any case, my lord, these everyday MLS politicians in the interest of public, they after knowing that the tenures are over, they make a request to post someone, but that cannot be.
No, he has not made a request. He has said this respondent should be posted there.
Yes, after knowing that the present incumbent is already has already his tenure is already over, then a request has been made.
But question is, my lord, why this gentleman, my lord? There is lot more.
Request
my lord,
is can always be made by the MLA, my lord.
I mean, in my humble submission, let
And he is not from that place.
No, my lord. Rowing,
Same district,
same district, my lord.
different constituency.
My lord, different constituencies, but this division is they are looking after the same district, this constituency also. This division, PHE division is looking after the constituency of this MLA also. Otherwise, petitioner will not have a vested right to remain at that place of posting, my lord.
I have Mr. S. Lampu, I'm counsel for the petitioner, and Mr. and Ratan, learned AAG for the respondents 1, 2, and 3. This writ petition is directed against the order dated 16 July 2023 issued by the Secretary PHE and WS Government of Andhra Pradesh by number and set page 18. However, the petitioner who is you are an executive engineer who is an executive engineer PHE and WS division Roy has been transferred and posted as EE within bracket PND, comma, or stroke or CE, comma, PHE and WSD eternal. And in his place, the respondent number 5, who is also an EE within bracket PND, comma, or stroke or CE, comma, PHE and WSD eternal has been brought in. Also, though the petitioner states to have completed more than 3 years of posting at PHE and WS division Roy, comma, the petitioner has contended that the impugned order of transfer dated 16th July 2023 has not been issued in a public interest, in an administrative exigency and public interest, but the same has been issued on the basis of pure note dated 14 February 2023 put up by the respondent number 4, who is an MLA come advisor to the Honorable Minister RD and PR Government of Andhra Pradesh. Which note was put up to the Honorable Minister PHE and WS Government of Andhra Pradesh, and on the approval of the Honorable Minister PHE and WS, the MP order of transfer dated 16 July 2023 has been issued. Full stop. Issue notice returnable in 4 weeks. As Mr. Yatham Laman has entered appearance and accepted notice on behalf 1, 2, and 3. No formal notice need be issued. Extra copies of the writ petition are also be published to him during the course of the day. The steps for submission notice upon R4 and 5 will taken by registered post with AD as well as the usual process within 3 days. First of heart on the interim prayer. First of. The UO note dated 14 February 2023 is stated to be written by the respondent number 4, who is an MLA of 42 Dambuk within bracket ST Assembly Constituency, come advisor to Honorable Minister R.D. and Pierre, Government of Arunachal Pradesh, which note has been annexed, Annex 3 to the writ petition, is reproduced here in below, which reads as on the court Annex 3. Full stop. From Procedural, the aforesaid you are not dated 14 February 2023 as expected here in below. Above, it is noticed that the respondent number 4, the MLA come advisor to Honorable Minister R.D. Pierre, has proposed the posting of the respondent number 5 as executive engineer rank division for the approval of the Honorable Minister, PHE and WS. Full stop. What is this page 23?
Page 23 is type.
Oh, it is a type copy only, no? Okay. All right. Full stop. Thus, it appears that the impugned order of transfer dated 16 July so and so. I think issued on 24, huh? You add this, issued on 24 of July, appears to have been issued acting upon the U note dated 14 February 2023, put up by the respondent number 4, who had proposed the posting of respondent number 5 as executive engineer, rowing division. Full stop. Para. Since the petitioner has completed more than 3 years, more than
3 years.
has completed. Since the petitioner is stated to have completed 3 years of posting as executive engineer in rowing division, the transfer of the petitioner from rowing by the impugned order dated so and so may not, did I say, interfere? What did I say? Since the petitioner is stated to have completed 3 years of posting at the as executive engineer in rowing division, the impugned order of transfer of the petitioner dated 16 July 2023 may not have warranted interference by this court had the impugned order of transfer dated, all the petitioner dated 16/7/2023 was issued by the competent authority without the intervention of the respondent number 5 by the by the UO note dated 14 February 2023 as extracted herein above. Since the impugned order of transfer and processing dated 16 July 2023 of the petitioner as well as the respondent number 5 appears to have been issued on a proposal put up by the respondent number 4 by the UO note dated 14 February 2023. In the interim, till the returnable date, the impugned transfer and posting impugned order dated 16 July 2023 issued by the Secretary PHE and WS Governor Heavy by number so and so shall remain the state listed after 4 weeks.
Yeah, please, my lord. My lord, the petitioners are, my lord, drivers, my lord, in different rank and file, my lord, from constable, head constable and SI, my lord. And they are drawing the, my lord, great pay of, my lord, 2,000, my lord. My lord, by a policy decision of the government, my lord, which was, my lord, the said decision was, my lord, by an order dated, my lord, 29/2016, my lord, the Commissioner Transport, my lord, has issued an order, my lord, whereby, my lord, lordship will find at page 24, my lord.
You are praying for what?
I am challenging the, my lord, the decision of the, my lord, high level, my lord, committee, my lord.
High level committee.
Yes, my lord.
What is the decision?
Decision lordship will find at page 80, my lord. They are basically saying that, my lord, page 80 at my lord. Relevant will at page 85, my lord. One of the ground, my lord, we are challenging, my lord. It is also to mention that page 85, my lord. Second ground, my lord. First ground is at page 84, my lord. May I read, my lord? Rejection of our consideration, my lord. If the police department.
Rejection of your
Our, my lord,
representation.
representation, my lord.
For what? Upgradation of pay?
Upgradation of great pay only, my lord.
Oh, great pay.
Great pay, my lord.
Okay.
My lord, it was extended to all the drivers of the state of Arunachal Pradesh of all the departments, in the all the departments, my lord, except the police department, my lord. May I read, my lord? If the police department implements the said order, enhancement of the grade pay of the constable driver from 2,000 to 2,400, it will create pay disparity amongst the constables executive, my lord.
We can issue notice, I think.
My lord.
Mr. R. Segal, counsel for the petition. Petitioners. How many of you?
54, my lord.
Okay. Police department.
Police department drivers, my lord.
And Mr. Estapin, you represent all.
Yes.
Senior government advocate, represent all the respondents. Issue notice, return every 6 weeks. Since Tapin, senior government advocate has entered appearance and accepted notice on behalf of all the respondents, no formal notice will be issued. Extra copies of the writ petition, common requisite in number, be furnished to him within 3 days. Listed after 6 weeks.
Number 4.
Yes. Timing.
My lord, my officer has come home,
So what?
and we have filed the affidavit also.
You are appearing for whom?
Power department.
Power demand. Okay, after some time.
Lordship, pleadings are completed. It
What
may
is the
be-
matter about?
Lordship, it's a land acquisition matter, Lordship. It's regarding compensation for, and it is my prayer that the respondents have destroyed my land, Lordship, including the vegetation area, Lordship.
Hmm.
So I'm claiming compensation from the respondents, Lordship. My land is located at Boleng. It's 6 kilometers from Boleng, Lordship. So they have dumped mud and other debris around in my land. Accordingly, it has been destroyed, Lordship. Lordship, I'm praying it may be fixed for admission hearing, Lordship.
This has come for admission here, eh?
No, we had sought some time for filing the reply, so Lordship will not be filing our reply. So it may be fixed for admission hearing. Lordship. It is my prayer.
You want to file reply?
We had sought time on the last occasion to file reply, but we will not be filing our reply, Lordship. So pleadings are completed, Lordship.
Okay. Yes, Mr. Riro. Can it be dismissed today?
No, Lordship.
It cannot. Then can we allow this today? Can we allow the writ petition today?
It won't be possible.
So neither it can be allowed nor it can be dismissed today. Then we have no option. When? Mr. G, had Mr. G Talo Lamed counsel for the petitioner and Mr. Idira Lamed additional senior government representing all the respondents.
There is union also involved, Lordship.
Union is also there.
Yes, Lordship.
Haryana is not aware of also having a respond. Yes.
The grave is.
Okay. For the state of AP and this. And Sora Lamed counsel for the Union of India. Mr. Talo Lamed counsel for the petitioner. Promised that petitioner would not be filing a rejoinder to the counter affidavit filed by the respondent. Union of India is not filed.
No,
Oh,
they filed, Lordship.
huh?
They filed their report.
You have also filed. Okay. By the respondents. Oh. Oh. We filed the press for listing of this matter for admission hearing
2 weeks,
after
Lordship. 2 weeks, Lordship.
4 weeks. Aspirate for listed for admission hearing after 4 weeks.
May I please, Madam?
Yes.
My lord, I'm appearing on behalf of the petitioner on the instruction of the conducting counsel, Mr. Saxena, to withdraw this petition.
Okay. Mr. H.K. Jamo. You are on record? No.
I'm not on record.
Appearing on behalf of Mr. K. Saxena, the counsel for the petitioner, and Mr. T. Tagum, the standing counsel for the health department. Appearing for the respondents. Mr. Jamo. Learned counsel on instruction of Mr. K. Saxena, learned counsel for the petitioner. Mr. Jamo, learned counsel, submits that he has been instructed by Mr. Saxena, K. Saxena, learned counsel for the petitioner, to withdraw the writ petition. First, in view of the above submission there, the petition is dismissed on withdrawal. Import order pass earlier. Shall stand vacated.
All right.
Please, madam. My lord, matter may be passed over for a while. Senior counsel is on court number 2.
Who, Kato?
Yes, madam.
What is the matter about?
In this matter, Your Lordship, we were going to get instruction from the food and civil supply for respondent number 5, Your Lordship. Still we have not received, so some more time will be granted, Your Lordship.
What is the matter about?
So transfer of AAY card holder, Your Lordship, from the petitioner claim.
Okay. Heard Mr. M. Sora, learned counsel for the petitioner, and Mr. P. Prangu, learned government advocate, representing all the respondents.
1, 2, 3, 4, and 5, Your Lordship.
Ah,
Yes, all the respondents.
oh, praise for. And is granted. Have you received instruction? No.
No. Only for respondent number
For
4,
the-
we have filed, Your Lordship.
For the respondent number 4 has filed affidavit.
Yes, Your Lordship.
It is not on record. Affidavit.
It's on record, Your Lordship.
When did you file? Okay, it is there. All right. Ms. P. Pamela, government advocate, appearing for the response, submits that the counter affidavit by the respondent number 4 has been filed. She further submits that counter affidavit by respondent number 2 and 5 would also be required in the instant case, for which she pressed for and is granted 6 weeks time to file counter affidavit by the respondents 2 and 6, 2 and 5,
It's 2 and 4.
listed after 6 weeks.
My lord, this matter may be passed over for a while.
Which one?
Item number 9 to
9 to
12.
okay, arbitration matter.
M. Kato is on spot to.
You are for whom?
I'm for the petitioners.
Okay.
All of this.
Affidavit filed.
They have not filed.
They have not filed.
But when this can is going to the last day.
Let the council come. Okay, after some time. Okay.
Oh.
Yes.
Right to you.
This is the matter where the recall of the order has been, appointment order has been challenged.
Member of the
Public Service Commission.
Member. People of the member.
Yes. So far as the pleadings in the petition, as well as the reply filed by the respondent government is concerned, matter very limited. The appointment was preceded by an advertisement. Lordship, may kindly have a look at the advertisement at page 20 of the petition.
Yes.
This is an advertisement of 21st of November 2022. The governor of Arunachal Pradesh is pleased to invite applications from the citizens of India for filling up of following vacancies in the APPSC in terms of Article 316 of the Constitution of India. Chairman APPSC 1 number, member APPSC 3 numbers. Eligibility criteria: persons with outstanding career, outstanding academic excellence, and capacity to judge independently suitability of candidates for a civil post service under the government of Arunachal Pradesh. He or she shall not be a member of parliament or member of legislature of a state or union territory or hold any other office of profit or connected with any political party. The rest are not very relevant. Next page, also kindly see small d under the column how to apply. They have mentioned integrity stroke character of antecedents. The integrity of the candidates shall be beyond doubt
They shall be free from all types of criminal and other charges. However, the appointment of the selected candidate shall be subject to verification of character and antecedents by the police. And this advertisement I have read and specifically pointed out the serial number 1, that is the eligibility criteria. And in this serial number 5 at page 21, to show that what are the requirements for appointment as per the advertisement, and the last sentence of this page 21 at serial number 5D shows that the appointment shall be subject to only police verification and nothing else. For the appointment process to be complete, what is required is the police verification and nothing else. And integrity has to be beyond doubt, that is there. And he should also be free from all types of criminal and other charges. This is the requirement. Now, page 24 onwards, manner, the application with biodata of the petitioner was submitted in pursuance of the advertisement. I would like to just point out, my lord, since the advertisement itself says about his integrity, academic excellence, etc. Let us see, my lord, what kind of academic excellence, etc., and other qualifications he has. Page 24, Lord, will kindly see. Serial number 1 in the table of form, my lord, the qualifications, etc., given of the petitioner. Lord, will find metric qualification matriculations board CBSE 1983 with 77.46% of marks. Then class 12 joined National Defense Academy through UPSC exam and service selection board after class 11. Graduation JNU NDA 1987, FGPA 4.72. Then PG MSc in Defense and Strategy Studies, Madras University 2003 with 69.30% of FGPA. Then MSc in Counseling Psychology, Martin Luther Christian University 2014, CGPA 3.34. Then other qualifications: 3 years joint training in National Defense Academy, Pune, 1985 to 87. 1 year military training at Indian Military Academy, Dehradun, 1986. Then 6 months young officers course at Infantry School, Swenso. Then Commando Course Officers, Belgaum, 1990. Security Course Officers in Military Intelligence Training School and Depot, Pune, 1994. Attended Counter-Insurgency and Jungle Warfare Course, Veringta, Mizoram, and acquired instructor grade in 1995. Subsequently posted as instructor and imparted training to Indian and foreign army from 1996 to 1999. Underwent Junior Commando Course, 1999. Passed Defense Service Staff College competitive examination and underwent 1 year course at Defense Service Staff College, Wellington, Tamil Nadu. Other than this manner, re-employed after retirement in ad hoc station headquarters, Teju. Then brief service particulars, post held, commissioned into Jat Regiment in December 1988, served as International Officer, Adjutant and Company Commander in LOC. Then Company Commander 1996, 1919 instructor in Counter-Insurgency and Jungle Warfare School, etc. 2004 Deputy Quartermaster, General QMG. 2005 also it's there, 2009. Then it continued, 2012, 2017, 2019, 2021. So all these assignments he has discharged successfully. Then next page 27, Lord, you can see the academics. Passed entrance examination from Sainik School, first rank in academics in school, won National Talent Search School class 10 after written test. Then won first prize in English essay writing in government school, passed National Defense Academy, won book prize for obtaining highest mark in geopolitics. Then in sports also, first in cross country race, best athlete, medals in cross country, third among Indian Army officers. Then professional also participated in so-and-so, awarded commendation of GOC in Sea Northern Command for in border skirmish, etc. So it continued, my lord. With these background and credentials, my lord, he made the application. Therefore, at page 29(4), my lord, I have annexed the copy of the committee which was constituted for considering their cases. And the committee was constituted by the governor for considering their applications. Page 30, Lord, will find the order of appointment. In exercise of powers conferred under clause 1 of Article 316 of the Constitution of India, read with clause 4 of Arunachal Pradesh Public Service Commission Regulation 1988, the governor of Arunachal Pradesh is pleased to appoint so and so as member of Arunachal Pradesh Public Service Commission. The pay and allowances of the post shall be governed by clause 6 of the Regulation 1988 as amended from time to time with effect from the date he assumes the charge of his office. He shall hold office for a term of 6 years from the date on which he enters upon the office, or till he attains the age of 62 years. Then, my lordship, he was in a post retirement engagement. Page 31 is the letter by which he has been informed that premature release from re-employment. So, as a premature release from re-employment in RO above mentioned here, offer has been approved by competent authority. Then next page, page 32, my lord. So and so has been, petitioner has been struck of ration strength with effect from 16 February 2023 while proceeding on premature release from re-employment. So he was in a re-employment because of his employment here, my lord. Process was going on, he has resigned there. And page 33 is an order with regard to the intimation about oath-taking ceremony. It was informed by the Joint Secretary to the Government of Arunachal Pradesh. With reference to above mentioned subject, it is to inform you that the Honorable Governor of Arunachal Pradesh has consented to administer the oath of office and oath of secrecy to the newly appointed chairman and members of Arunachal Pradesh Public Service Commission on 17th of February 2023 at 1500 hours at Darbar Hall, Raj Bhavan, Itanagar. In view of the above, you are requested to kindly arrive at Raj Bhavan, Itanagar by 14:30 hours along with your family members for taking oath of office and oath of secrecy as member of Arunachal Pradesh Public Service Commission. Then thereafter, my lord, as some agitation was going on with regard to the functioning of the APPSC prior to their appointment, there was some agitation, and I have annexed the paper containing the news item that PAJSC urges government to postpone oath taking of APPSC's members. And in this news item, Lord will kindly see on the left hand side column, there are 1, 2, 3, 4 columns, left hand side, extreme left column, second paragraph. The PAJSC argued that the newly appointed chairman, retired Lieutenant General so-and-so, is 61 years old and on the verge of retirement within a year, and demanded appointment of full-time chairperson who can complete 6 years term in the commission of office. The new chairman will have neither time to understand the system nor to cleanse it. This is an insult to the already chaotic state of the APPSC, the PAJC.
Newspaper may not be read.
Madam?
Newspaper may not be read.
Well, I'm showing this because this was the one of the reasons for which the oath-taking ceremony has been postponed. And Lordship will see from here, the objection was with regard to the oath-taking of the chairman only, not the member. This is what I'm trying to show from you. Then next page, my lord, page 35, 18th of April 2023. Is the order impugned in this writ petition, my lord. In public interest, the governor of Arunachal Pradesh is pleased to recall the government notification number so-and-so, dated so-and-so, appointing Pranay Poch Tari, retired as member, Arunachal Pradesh Public Service Commission with immediate effect. Thereafter, my lord, a fresh advertisement was issued on 28th of April 2023 for undertaking a fresh exercise for appointment of the chairman as well as the members. Thereafter, my lord, so far as this petition is concerned, I mean, some sort of protection was given by virtue of an interim order, but the petitioner approached the Honorable Division Bench and further order was passed. stalling further process of fresh selection, directing disposal of the present petition. My lord has seen the manner in which the process was undertaken for appointment of the petitioner as a member of the Public Service Commission. Now, initially, the oath taking ceremony was postponed, and subsequently, the order itself of appointment of the petitioner was recalled. And when we changed, the government has filed a reply, and the in the reply, my lord, I will possibly have to read one or two paragraphs to show what are the grounds on which they would like to defend the order impugning this petition. Lordship may kindly see page 4 of the affidavit of opposition filed by respondent number 1, 3, and 4. Before I make my submissions, I'll have to point out these pleadings. Then I'll make my submissions, then I'll go to the constitutional provision, and thereafter the judgments on which I'm placing reliance. Page 4, paragraph 7, Lordship may kindly see. There with regard to the statements made in students of the answering respondent humbly begs to state that the agitation was not only by PAJSC, but by the public in general, including some student bodies. Then the next paragraph, the second stated, further the ANSU submitted a letter on 3rd of December 2022. Next paragraph, paragraph 8, my lord.
Paragraph 8.
8, my lord. And the first sentence I'm avoiding because this is a stereotype thing. Third line from the paragraph 8, my lord, from the top. Further, all the students union submitted a letter on 3/12/2022, which contained 13-point memorandum to the government for consideration. The answer respondents humbly beg to state that owing to the unprecedented public demand, the Honorable Chief Minister invited all the stakeholders, including the ANSU and PAJSC, for a meeting on 8/2/2023 to discuss the issues raised by the public. In the same meeting, the 13 issues raised by ANSU earlier were discussed and stakeholders were updated with regard to the steps taken by the government thereon. It was inter alia minuted, and this is important. It was inter alia minuted to recall the appointment orders of chairman, stroke members, and place the matter before the cabinet. So here the decision was taken. It was further mentioned in the minutes to constitute a fresh search committee to conduct a fresh selection process. It was further decided that in terms of the suggestion given by the public, a column for declaration of properties of the applicants would be added in the application form. Pursuant thereto, the matter was considered by the cabinet in its meeting held on 29/3/2023, and it was recommended to recall the appointment orders in public interest. Therefore, the governor was pleased to recall the appointment orders by notification dated 18/4/2023. The answering respondents humbly beg to submit that the decision-making process which led to the recall of the appointment orders of the chairman and members of APPSC does not suffer from any illegality or arbitrariness. The positions being primarily repositories of faith and public confidence, the ground of public interest is always available to governor to cancel or recall the appointments on the aid and advice of the Council of Ministers prior to their assumption of office. It is categorically stated that the appointment process of the petitioner was not completed, and hence the action of recalling or cancelling his appointment does not violate any of his rights. Then, my lord, next paragraph 9, I will not read the whole paragraph. I just point out specific areas where they have taken some defense. Page 6, my lord, somewhere in the middle, Lord will find a joint reading of Article 3.1. They have referred to the provisions of the Article 9 Constitution, and then they say a joint reading of Article 316, 3162, and proviso B to Article 3162 makes it clear that even after the governor issues an appointment order under Article 316 clause 1, a person does not automatically become a member of Public Service Commission unless he enters upon his office. Only after a person has entered upon his office, the rigors of Article 317 would be applicable to him. In the humble submission of the answering respondents, the makers of the Constitution clearly made a distinction between appointment and entering upon office, and it is only when such office is entered upon under Article 316 clause 2 that the rigors of Article 317 would come into play. The above aspect is further fortified from the notification dated 7/2/2023 by which the order of appointment as member APPSC was issued in the name of the petitioner. It has been clearly stated in the said order that the petitioner shall hold office from the date on which he enters upon the office. In order to enter upon the office, the petitioner is required to swear the oath of office and oath of secrecy, which is to be administered by the Governor of Arunachal Pradesh in terms of clause 4A and 4B of the Arunachal Pradesh Public Service Commission Regulation 1988. As such, without the oath having been administered, the petitioner had not assumed the office of member APPSC, and hence the procedure provided under Article 317 for removal of a member of Public Service Commission is not applicable. Lordship may kindly note this because I'll have to make a submission on this also. They are specifically taking a stand that since oath of office was not administered, so removal process under Article 317 will not apply. The answer respondents further begs to state that regulations of 1988 have been framed under Article 318 of the Constitution. The requirements of taking oath of office and oath of secrecy by a member of APPSC were inserted by way of amendments which were notified on so and so and so and so, respectively, which admittedly are not under cherished. As such, it is a mandate of law to take oath of office and oath of secrecy prior to assumption of office. The petitioner not having taken oath, he had not assumed the office and hence was not a member of APPSC on the date on which his appointment was recorded. Then again, para 10 also they have taken the same step that for not taking the oath of office, the appointment process was not completed. I may not read this matter. It's very page 9, para 11 will be of some significance. Page 9, para 11. That the statements made in para 19 of the petitioner incorrect, baseless, and misconceived, hence the same are categorically denied by the answering respondent. It is categorically denied that the new advertisement dated 28/4/2023 contained the same terms and conditions like the earlier advertisement dated so and so. The answering respondents further humbly beg to state that the advertisement dated so and so was issued adding an additional requirement of declaration of properties of the candidates. The authorities, after considering the suggestion put forward by the stakeholders, were of the opinion that such a requirement would ensure selection of candidates who would be able to impartially carry out the functions of the commission. The earlier selection process not having such requirement, it was in the interest of public at large to recall the appointments made thereunder. The answering respondents further humbly beg to submit that in view of the facts and circumstances, as well as the submissions narrated herein above, it is apparent that the impugned decision-making process does not suffer from any infirmity. Next paragraph will be of some relevance manner again. That the statements made in para 20 of the petitioner incorrect, baseless, and misconceived, hence the same are categorically denied by the respondent. It is categorically denied that the order dated 7/2/23 had conferred any right upon the petitioner. The answering respondents humbly beg to submit that although the order of appointment of the petitioner as member of APPSC was issued on 7/2/2023, however, till the petitioner entered upon his office in terms of Article 3162 after taking the oath of office and oath of secrecy in terms of regulations of 1988, the petitioner could not have been deemed to be appointed as member APPSC. Hence, the impugned action of recalling the order of appointment of the petitioner doesn't suffer from any infirmity. The answer respondents further humbly beg to state that the governor having the power of appointment under so and so, he has also power to recall, cancel such appointment. And possibly this is based on minor section 21 of the General Process Act. I'll refer to section 21 later on, my lord, in course of my submissions. On the basis of, my lord, these statements made in the affidavit in opposition, my lord, they intend to defend the order of recall which has been challenged in the writ petition. My lord, we have filed a rejoinder to the affidavit in opposition. Just one or two paragraphs from the rejoinder may be relevant for the purpose of my argument, I mean, that I'll point out. It's not a very big one, very small one. And from there, just one or two paragraphs I'll pick. Lord, you may kindly have a look at paragraph 5 of our reply. Paragraph 5, well, replying to paragraph 7 and 8 of the affidavit in opposition.
Yes.
The statements made in paragraph 7 and 8 of the affidavit are irrelevant, baseless, and misconceived, and as the same are hereby denied. The deponent begs to state that the letter dated so 3/12/2022 submitted by all Nishi Students Union, which has been taken into consideration for recalling or cancelling the appointment of the deponent, does not contain any demand or objection against the appointment of the deponent as a member of the APPs. Furthermore, the said agitation is with regard to illegalities and malpractices occurred during the tenure of.
Yes.
One paragraph 5 about affidavit of that. But then I have to read it. Finally, reply. And there are there are finds which is what reply.
Okay.
Every bottom of paragraph 5. Paragraph 7 people there are in the same submitted by all the people which has been taken into consideration or cancelling the appointment of the deponent does not contain any demand or appointment of the deponent. What does it say in this means with regard to illegalities and malpractices occurred during the period sought by the agency members, and the same letter also cannot be a basis for cancelling the appointment of the deponent. There is a same demands where on 3/12/2022 when the appointment of the deponent is by 7/2/2023. Above apart, it is partly mentioned that the respondent has emitted a cancellation of the appointment as a member of the agency who was making some contributions there is 18 to 2023. We will be covered up to some organizations in all against the illegality and for giving the tenure of our the stage clearly establishes that the factors taken into consideration for cancelling the appointment of the deponent as a member is be forward and without clearly any discrepancies and irregularity found illegal and arbitrary, and there is no problem report. And then there will be about
Which paragraph you have read?
paragraph 5 at page 2 of our reply.
Okay.
Paragraph 5. Basically, what we wanted to say in this is, and although they are saying they have taken into consideration the objection raised by the organization. Their objection was on 3rd of December 2022, where the petitioner was appointed on 7th of February 2023. So that cannot be a ground for cancelling the appointment of the petitioner. This is what we have said here. And at the bottom of the state paragraph, we have said that appointment of the petitioner was subsequent to a and pursuant to a proper selection process, which did not have any anomalies or irregularities. My lord, as I have pointed out from the affidavit in opposition of the respondent government, Lordship will kindly see the basis for recalling the order are like this manner. First, they say that
Just a moment. It is likely to take some, shall we dispose of the miscellaneous matter first? Some counsel from outstation
My-
is also is waiting, I think,
Yes.
arbitration matter.
this matter will take some time. I'm just expressing one difficulty. My learned AG also will have to give his reply. Tomorrow, I have some difficulty in.
No, we'll continue the hearing.
Well,
We'll try to
Finish it.
finish the miscellaneous matter within half an hour.
well,
Yes. Yes.
My lord, we have filed affidavit and when the officer officer someone has appeared before this honorable court today.
No, why the officer was called?
Lordship, there was a additional affidavit filed by the petitioner. And in that additional affidavit, inquiry report of the official was annexed. And this honorable court has directed me to sort this instruction. Even I have placed that instruction. But that instruction, I believe, it was not conclusive. So this officer was called.
Instruction?
My lord, writ petition was filed challenging a recommendation for cancellation of an land allotment in my favor. Now, during the pendency of the writ petition, an inquiry was conducted by the joint director of agriculture. That I put on record by way of filing an additional affidavit. But the directorate did not file a reply. So that is how your lordship wanted that the officer who conducted the inquiry be present in court today. This affidavit they furnished only today. I don't know if it is a record also.
Neither counter affidavit was filed,
Yes.
nor any instruction on the additional affidavit filed by
Yes.
you
Yes.
was before this court. Though the writ petition is of the year 2018,
Yes.
19, 20, 21, 20, for the past 5 years, department was not filing a counter affidavit. Is not it?
Yes, sir.
Nor any instruction on the additional affidavit filed by the petitioner was given to you.
And yes, not written instruction. Although that the lordship, I was given the telephonical instruction. And accordingly, lordship, I have placed that argument that the inquiry report as annexed in the additional.
Court proceeding is not, court proceeding is not conducted on telephone.
Lordship.
So that is what I was wondering, why the officer was called. Officer of the department is never called by this court. So here perhaps the counter affidavit was not filed for the past 5 years.
Exactly, lordship. It was for the region only. Why?
5 years.
Yes.
And no instruction was given despite the repeated time being granted. Perhaps that is for that reason only the officer was called here.
Yes, yes, exactly.
Now you have filed affidavit.
Yes, Lord. In both in the additional appeal as well as in the repetition.
You have filed department has filed counter affidavit also.
Yes, Lord.
Today only, ma'am, cannot be there.
And you have filed affidavit in opposition in his to the additional affidavit also.
Yes, Lord.
Okay.
We are saying that, Lordship, in fact, on the basis of the issue, order issued by the competent authority, respondent number has carried out the inquiry. And this inquiry report, which has been annexed in the additional affidavit, is correct. And the officer is telling me that how this allotment could not be given to the petitioner. It is because that this repetition is pending since 2018. So the matter being subject before this honorable court. So why his allotment could not be restored. That is.
So you are for restoration of his allotment.
Lordship, yes, as per.
Huh?
Yes, Lordship.
That is the stand taken by.
Yes, Lordship.
Then why you wanted to cancel it?
Lordship, because there is a complaint from the executive engineer, power department. And on receipt of that complaint, the government has directed the officer who is respondent number 4 here to carry out the inquiry. After the inquiry is carried out, it was found that the land is feasible for the allotment. Even the land, Department of Power has not applied for allotment. Neither do they possess the allotment order.
So whose land it is?
It is government land only.
Which department?
Power department.
Power department.
Yes, they are.
So you want to give a portion of the department of the land of Department of Power to the petitioner?
No.
Not power department, not allotted.
They are
The government,
yes.
yes, not the power department's land.
Huh?
It's not the power department's land. They have no allotment.
But it is in the possession of Power Department.
No. It is in my position already allotted to me.
Huh?
Part of land given to the petitioner as in possession of the Power Department. Now, my lord, about additional affidavit, my lord.
All right, just a moment. You have been furnished with a copy of the affidavit.
No.
Why you have not furnished copy of the affidavit?
I'm very sorry, Lordship.
As well as your objection to this affidavit in opposition to the additional affidavit filed by the petitioner.
Yes, Lordship.
Have you furnished a copy to him?
No, Lordship.
Why have you not furnished?
Sorry, Lordship. In fact, copy was made available, but there is again. Lordship.
There are too many buts. After you have filed counter affidavit after 5 years. So there also,
The problem again is, Lordship, I should not say this, Lordship. We in fact give the copies to the advocate clerks, Lordship.
No, that is no manner of giving, serving a copy. Here around you.
I'll serve it right now, Lordship.
All right, we'll consider since affidavit has been filed after 5 years.
Yes, Lordship. I'm considering that.
You file reply if you.
My lord,
Yes.
I need to look into it, my lord. Additionally, my lord, in the additional affidavit by the petitioner, my lord, I have sought instruction, my lord. So instruction on the EE, my lord, written instruction, my lord. I pray that, my lord, let this be part of the record, my lord.
Saying what?
Additional instruction to the additional affidavit, my lord, by the petitioner, my lord.
What is that to the effect?
That effect, my lord, my lord, may kindly look at.
Oh, you just tell what is there.
We are saying.
You also want the land to be given to the petitioner.
No, my lord, we are saying, my lord, we were not the party to this inspection, my lord.
Huh?
This power department was not a party to the inspection, my lord.
Not a party to the
Inspection, my lord, the joint inspection report. My lord. Inquiry.
inspection. Input report. Okay. You file reply. You file it in the form of affidavit. Okay. You have also been added as a respondent.
Yes. Yes, a respondent number, my lord. 7, my lord.
And the officer who had submitted an inquiry report was competent to inquire into the status of the land.
Lordship, yes, since he is a joint director in the
Okay.
department also.
If he is competent under the law to inquire, we will use the officer to inquire in other land also.
Lordship, for that,
Your competency you are deriving from the nature and status of the post the officer is holding.
in fact, Lordship, I have not carried out,
Competency has to relate to some rules.
Lordship,
That will be the issue you will have to answer. Today, we are running short of the time. We are not going into it.
Lordship, officer who has carried out the inquiries, Lordship, he had not carried out the inquiry on its own, but he was directed by the competent authority.
Which competent authority?
Lordship, secretary, I believe, Lordship.
Secretary is empowered to.
Must be, Lordship, since he is the head of the department, Lordship.
Must be.
I am not sure, but Lordship, he must be, Lordship.
Land department has to set its house in order. Today we have no time. Huh? Lot of cases to be attended. So the secretary must be. See, once you say that he is a competent to inquire into the disputed land, we'll use him for settling disputes to others. Not many disputes are there. Think about it. These are the questions you will have to answer.
Lordship.
Huh? Today we have somehow been able to secure affidavit and instruction after 5 years. We will go into these questions. Mr. D. Pamela, counsel for the petitioner. Mr. D. Kamduk, learned standing counsel for land management department. Representing respondents 1, 2,
3 and 4.
3, and 4. Ms. P. Pangu, learned government advocate for respondent 5 and 6. And Mr. L. Permit, learned counsel for the respondent number. Standing counsel for the power department. Representing respondent number 4. Sorry, 7. Pursuant to order of this court dated 24/7/2023, the Department of Land Management has now filed a counter affidavit.
On behalf of 1, 2, and 3.
When was it filed?
Today.
7th August. But your affidavit is titled as a rejoinder affidavit?
With the,
Two evidence is I have submitted earlier. One, rejoinder is the affidavit.
the additional affidavit.
Yes, responding to additional affidavit.
There is an additional affidavit to
Okay.
petition. The rejoinder is
to the additional.
Counter affidavit in the writ petition has filed counter affidavit by the respondents number 1, 2, and 3 in the writ petition, as well as an affidavit titled as within inverted comma, a rejoinder affidavit on behalf of the respondents number 1, 2, and 3 to the additional affidavit filed by the petitioner in the writ petition, inverted comma, close. Full stop. Both the opposite affidavits. Mr. Perme, learned counsel, learned counsel for the power department, submits that he has not been furnish a copy of both the affidavits filed by the Department of Land Management today. Mr. In view of the above, Mr. Learned counsel for Land Management Department shall serve a copy of both the affidavits to Mr. L. Perme, learned standing counsel for the power department during the course of the day. First. List it after 4 weeks to enable filing of a reply by the petitioner as well as by the respondent number 7, if so advised. Yes. You take back this, Mr.
Personal appearance of the officer may be dispensed with us.
Okay.
Yes.
The officer who is present in person today, in persons of the order dated so and so. Sorry, further appearance of the officer is directed to remain present in person before this court by the order dated so and so is hereby dispensed with.
Much of that.
Further presence, I said, no? Yes.
There are 4 cases. The notice was issued on 8th of May in this case. DSCI is representing the sole respondent.
On the last occasion, my lord, we sought for the time for filing affidavit, my lord, raising a specific issue. But one thing, my lord, there is the whole, my lord, the case of the petitioner is, my lord, the price escalation, my lord. There was a delay in the execution of the work, and during this period, my lord, the price has gone up to certain extent, my lord, and they are raising the price, my lord, escalation. So therefore, in
just a moment, who is the petitioner here?
That's a company, a road construction company. We were allotted certain works for construction of roads. These are 4 different.
You are the petitioner.
Please.
In all the
all.
Have you filed an affidavit?
My lord, our affidavit we have already provided, my lord. It is under process for my lord vetting. So the moment, my lord, we received my lord, the vetted copy, my lord, will file. My lord.
Affidavit will be required.
I would request this honorable court, the affidavit otherwise would not be required because their only objection, apart from the merits, that is to be seen by the arbitrator. But as far as the appointment of arbitrator is concerned, their only objection, there is no objection because as per the contract provides for appointment of an arbitrator who is a serving official. But after the amendment, that is not possible and I have not given a waiver. So as per their letter also, they also say that we are unable to appoint because of the amendment of the act. So
amendment of the act.
Please, as per section 12(5) and the read with 7th schedule, serving official cannot be appointed as arbitrator. So regarding that, there could not be any objection.
Where is the?
Please, that is at page 80 is the arbitration clause. Clause 70.
Page number?
Page 80.
80.
Please. I'm referring to the arbitration petition number 1 at item number 9,
Yes,
clause 70.
70.
Please.
All this. Well, let there be an affidavit.
May kindly also have their reply to my letter invoking arbitration at page 123, annexure 10.
Your clause itself is as such the serving
Please.
officer having degree, etc., etc.
Yes, but
You
after,
have agreed to it.
but after the amendment, that is not possible. May kindly have annexure 10, page
When-
number 123.
When was the amendment made?
That was earlier to the contract, but this is a standard form contract. So this anyhow requires my waiver. I have refused to give the waiver during in my notice invoking arbitration. May kindly have the reply also.
This agreement was signed when?
This was signed in 2020,
2020.
please.
Then
16,
when,
12, 2000.
when was the agreement?
The amendment was earlier.
Amendment was made when?
This was in 2015.
15.
Please. Please.
When was the?
That is in 2015. That is prior to the,
Well, then why did you sign this agreement?
that is a standard form.
Okay,
contract.
still let the affidavit come. How much time?
4 weeks time.
Oh, hard, mister? Your name?
Any Monday.
Your name?
KPS Virk.
Okay, counsel for the petition, you give your name is
Please.
not there.
Please.
And Mr. M. Katul, DSC, who pursued and is granted for the 4 weeks time to file affidavit, listed after 4 weeks.
Please.
Yes.
Look, up to 9 minutes, 10, 12 minutes.
Same old. This will also take some time.
This will take.
So we better proceed with the case, earlier case.
Yes.
Any,
Earlier one state has urgency. So I will-
yes, anybody has, any urgent matter from item number
So far as
16 to 16 onwards.
But so far as this item 15 is concerned,
Ah.
your lordship may kindly fix it.
When?
If it is not 21st. I have another matter fixed here on 21st, can it be on 21st? Possible. Today, the other matter will go.
21st, 19 to 23rd, I have training. So maybe before that. I mean. Fourteen to 18, within 14 to 18, any dates? Can be fixed on 17.
This is all.
14.
14.
Oh. On the prayer of the council appearing for the party, and as agreed to the council appearing for the parties, listed on 14th.
Madam, may I pray that item number 35 minutes supplementary hearing, madam. Madam, this matter may be taken up tomorrow, madam.
Tomorrow? Why? Any urgency?
Madam, it is,
What is the matter?
madam, the petitioners are going to be, madam, over age. This is regarding service matter, madam, appointment. Advertisement was called for, madam. In the meantime, madam, out of the the advertisement, madam, leaving this, madam, petitioner aside, madam, given appointment to the persons who has not appeared at all, madam, in the examination process.
Next week?
May I pray that I ask next week? Day after tomorrow, madam. Subject to your lordship,
14.
14.
Monday. Okay. On the prayer and compliment of list is on 14. Yes.
Please.
28. Yes. Okay, just a moment. In item 28. Ha. 28 and 29. You want to file affidavit? In 29? Huh? 12 August. 12 July.
So he informed the, I also informed the council to the legislature. Actually, he by this day, he came from the by this day, so he was available. So he accepted for the administration back. So he's, yeah. Five affidavits.
He did not appear earlier. That's why I think he was disowned. No, that's immaterial. Okay. What is to be done today? Okay, all right. Now we'll list it after 4 weeks. 28 and 29.
Lordship, in item number 18, Lordship, the actions of pleading is over.
Which one?
Item number 18, Lordship.
Ah.
So the matter may be fixed for.
No, unless the any effective order is required to be passed, we'll assume the matter. Those who say that some order is required to be passed, that we can take it up.
Yes, pleading is over. So matter may be fixed for admission hearing.
Which one?
Item number 18.
18. Okay, on the prayer of Mr. A. Sarangnarkam, people, this is admission hearing after 2 weeks. Okay.
Please, ma'am. Look, I beg to mention.
Okay. Personal appearance of which respondent? Huh?
Content number 2.
Respondent number 2 is the further personal appearance. Personal appearance are directed today.
Yes.
Okay. Just a moment. Then you write in item 29. Pursuant to the order dated. Pursuant to the earlier order of this court, the respondent number 2 is present in person today. Who summarizes that the affidavit has also been filed.
Yes.
In view of the above, listed after 4 weeks. Further appearance of the respondent number 2 in person is hereby dispensed with for the time being.
Well, Lordship, in item 29, there is status quo, Lordship. That has to be maintained.
Oh, just a moment. Just
They are violating the
see,
status
just a moment. Personal appearance directed in which case?
contempt case.
Contempt case.
Contempt case.
Then you write in 28. Well, this G. Tarak was appearing in which case? Tarak was mentioning 28. He is not there.
Yes, this is 28 is content case, and
Huh?
29 is the repetition. Actually, the entire matter was fixed for this period.
Where is Tarak?
Item number 28 is contempt.
You are appearing in contempt,
Yes, I
also in writ petition.
I also.
Okay. You write this order in item 28, no? Which I have said. Then, list both the case after 4 weeks. The status quo order passed in item 29 shall continue till the next date of the stay. Okay.
May I please, I'd like to mention item number 34. So the matter is today fixed for order. And this morning I have filed already rejoined. Also mentioned filing one unlisted IA. So this matter will be listed after 1 week, madam. Item 34, madam.
All right. Item 34.
Yes.
After prayed for by Mr. N. Raman and the council for petition list after a week.
Yes. Idea.
Rama? He said there is urgency in the matter. 34.
This, my lord, I have filed one IA. And then as well as I have filed rejoinder. I filed rejoinder of.
No, they had mentioned that I had allowed in the morning to be taken
Constraint
up.
of time, that's why, my lord, I mentioned time is shortage, so that's why.
We'll take it up next week. No, IA is coming up today. So this order will be brought in the IA. In the 10:30, somebody had made a mention. His junior.
Yes, ma'am.
I had allowed it to be taken up. So this, he's praying for now after a week. Okay, all this matter will be listed tomorrow. All right.
All right.
Okay.
All right.
Huh? Yes, and anybody who has urgent matter, that we can take it up from this 16 to, yes, 16 to 34. Yeah. This, just a moment. 28 and 29, that order will remain, huh? Hmm. Yes. Item 22.
My lord, the government said that they did not get extra copy, my lord, so they didn't file, my lord. Reply, my lord.
Government has not filed reply.
Your lordship, we have not been furnished with extra copies.
So, my lord, they think also, my lord. Matter of agent, we will furnish on that.
Item 22, you're right. On the prayer of Ms. P. Sangeeta, London Government Advocate, listed after 8 weeks for filing of a counter affidavit.
Your lordship, extra copies have to be furnished.
I'm giving you 8 weeks time. If they don't furnish you extra copy, you will get another 8 weeks. Okay.
Right, please, also would like to mention item 32. By this, I were including Deputy Commissioner Itanagar Capital Complex and SP Itanagar Capital Complexes, respondent number 12 and 13 in the petition.
You want to be?
Yes, we want to implement, yes. DC and SP.
Matter will be taken up tomorrow. Tomorrow.
Okay. Hello.
Lordship, item number 20, Lordship, maybe a zone. 20 is regarding cover decision, Lordship. Lordship, maybe a zone.
My lord, I'm different.
No, 4 weeks. For me, Lordship, we'll have to take this. Yes, and still they have to serve the copy, so we are.
Okay. Then none appears for the petitioner on the prayer of Mr. I remember it is listed up to 8 weeks for filing of the counter affidavit.
Yeah, please, my lord.
Yes.
I beg to mention item number 23. Service report is awaited in respect to respondent number 4. I am for the petitioner.
Yes.
Item number 23.
Then what you propose to do?
Matter may be adjourned after 4 weeks.
Okay.
Your Lordship, today we have received extra copies, Your Lordship, in this matter.
Okay. Mr. Any stay order is there?
No, no
No.
stay.
Okay. Mr. S.K. Jamal, counsel for the petitioner, and Ms. P. R. Vassal, governor who submits the counter, sorry, extra copy of the lead petitioner has been furnished to her by the counsel for the petitioner. Today only, in view of the above, listed after 8 weeks for filing of a counter affidavit.
Obliged, my lord. My lord, item number 21. The private respondent has filed their affidavit.
Okay.
So we will be filing rejoinder within 2 weeks. In the meantime, my lord, the government is yet to file the affidavit. The notice has been served long back.
What is the prayer, John?
So my
You
lord,
want to file rejoinder or you will give time to the government to file?
my lord, I may be allowed to file rejoinder within 2 weeks, and the direction may be given to the government to file their affidavit within 2 weeks.
What is the matter, Aman?
Matter pertain to promotion of the private respondent superseding the petitioner.
The matter is about appointment of private respondent to the post of JE on the physical handicap quota. Now the issue is whether they can challenge by appointment. They are locus.
No, my lord, this is not the matter.
All right, you file affidavit?
Yes.
Mr. T. Omo, counsel for the petitioner, press for any granted. 2 weeks time.
Yes.
Lord, I will pray for 3 weeks, my lord.
2 weeks time for filing of a rejoinder to the counter affidavit filed by the private respondents. Post law.
Government.
You are for whom?
I am the official respondent, power department.
You are for?
Private respondent.
Okay. Post. In the meanwhile, Mr. Parme, London, is standing counsel for the power department, first for 3 weeks time for filing of a counter affidavit. In view of the listed after 6 weeks.
My lord, after 4 weeks.
Okay, after 4 weeks.
Obliged.
I have gone through the relevant paragraphs of their affidavit filed by the government, my lord. Basically, what they have done is in the affidavit, they have taken twofold.
Where is Mr. Parme? L. Parme? Gone. This is your instruction in the earlier case.
Yes.
Yes.
My lord, in the affidavit, I have just taken the point from the affidavit. In the affidavit, they have taken a stand like this, my lord. That on 17th of February 2023, when the oath was to be administered, oath of office and oath of secrecy, on that day, some social organizations of the society called for a ban, pursuant to which an emergency meeting of the cabinet was held on the same day. And in the same meeting, they have agreed to recall the oath-taking ceremony. Lordship, kindly note, this is in paragraph 6 of their counter. I am just cutting short, my lord. And in paragraph 8, they say, after that, the Honorable CM had invited a meeting of all the stakeholders. And on 18th of February, that is the next day, my lord, a meeting was held of all stakeholders where it was minuted, not decided, minuted to recall the appointment itself after discussing with all the stakeholders. Then on the next day, that is on 29th of, no, so I'm not next day, 29th of March, I think, they have held another meeting of the cabinet. There are each one. And in the said meeting, after discussing with all the stakeholders, it was decided, now recommended, to recall the appointment itself. This is their stand number 1. Number 2, they say, since the oath taking did not take place, the appointment itself was incomplete. And at that stage, because of the public interest, considering the nature of appointment, the governor had the power to recall the appointment.
Yes.
Then they further say, for not taking oath ceremony, or in other words, before you take oath ceremony, you do not enter upon the office. And if you do not enter upon the office, then the rigors of section 30 of Article 317, which provides for the process of removal of a member, would not apply.
What is minuted?
Possibly they have discussed and they have made some resolution in the meeting. Normally in the minutes of the meeting, I mean, as we know,
This meeting is by the chief minister and
all the other stakeholders.
two organizations and other stakeholders.
Stakeholders, yes, ma'am.
Who are those stakeholders?
That they have not
Okay.
clarified, madam. And then their further submission, last submission, my lord, legal submission is that when the governor has the power to appoint, he also has the power to cancel the appointment. Possibly this is in terms of section 21 of the Jail Process Act, my lord, which provides that if any authority has any power to do certain thing, it has also the power to recall or vary that order or cancel that order. These are the submissions. Now, my lord, if we go to the stand taken by the state, specifically what we find, my lord, in my humble submission is that they have given the facts on why they have taken this decision, why they have done it. And then they say, then they have made some legal submissions that which show that whether they could legally do it on the basis of those grounds. I don't think possibly the issue that has to be decided by this court is minor. Yes, they have they were fair enough even giving the facts which led to the ultimate recall of the appointment order. Now the question that will arise for consideration by your lordship is whether on those grounds the appointment of a member of the Public Service Commission could be recalled. According to them, my lord, they have undertaken some process, and since in exercise of your lordship's power under Article 226, my lord, your lordship only will go to the extent of the decision-making process. According to them, they have undertaken some decision-making process. Thereafter, they have taken a decision. Possibly, they would like to argue that thereafter the Honorable Court will not go further to interfere with the decision itself, because the lordship will see the decision-making process. And my humble submission before lordship will be the grounds on which they have recalled the appointment order are not at all germane to the grounds on which they could recall, on which a person is appointed to an office of member of Public Service Commission, it being a constitutional position, my lord. And the Honorable Supreme Court having clearly said that it is not an appointment to an office or a post under the government of India or under the government of a state, my lord. It is a constitutional post. My lord, may I kindly have a look at Article 316 first. And so far as, my lord, I would just like to add one more, my lord. So far as the question they have raised about the fact that oath-taking ceremony did not take place, according to them, the regulation which has been framed by this state government, my lord, in exercise of power under Article 316, 2 possibly, 3, that regulation 4 and 4A of of this regulation provides for the oath taking. So since oath taking did not take place under the regulation, they have not entered upon the office. As a result, the question of following the procedure prescribed under Article 317 will not come. That is their submission. Lordship, may kindly have a look at page Article 316 first for a moment. Appointment and term of office. I'm reading Article 316 of the Constitution of India. The chairman and other members of a public service commission shall be appointed in the case of a union commission or a joint commission by the president, and in the case of a state commission by the governor of the state, provided that as nearly as may be, 1/2 of the members of every public service commission shall be persons who at the dates of their respective appointments have held office for at least 10 years, either under the government of India or under the government of the state, and in computing the state period of 10 years, any period before the commencement of this constitution, during which a person has held office under the crown in India or under the government of an Indian state shall be included. If the office of the chairman of the commission becomes vacant, or if such chairman is by reason of absence or for any other reason unable to perform the duties of his office, those duties shall, until some persons appointed under clause 1 to the vacant office has entered on the duties thereof, or as the case may be, until the chairman has resumed his duties, be performed by such one of the other members of the commission as the president in the case of a union commission or joint commission under the governor of the state. In the case of a state commission may appoint or for the purpose. 2 says, clause 2, my lord, a member of a public service commission shall hold office for a term of 6 years from the date on which he enters upon his office or until he attains, in the case of a union commission, the age of 65 years, and in the case of a state commission or a joint commission, the age of 62 years, whichever is earlier, provided that a member of a public service commission may, by writing under his joint hand address in the case of a union commission or a joint commission to the president, and in the case of the state commission to the governor of the state, resign his office. B, a member of a public service commission may be removed from his office in the manner provided in clause 1 or clause 3 of Article 317. Then clause 3 says, a person who holds office as a member of public service commission shall, on the expiration of a term of office, be ineligible for reappointment to that office. And Article 317 reads like this, my lord. Removal and suspension of a member of a public service commission, subject to the provisions of clause 3, the chairman or any other member of the public service commission shall only be removed from his office by order of the president on the ground of misbehavior after the Supreme Court, on a reference being made to it by the president, has on inquiry held in accordance with the procedure prescribed in that behalf under Article 145, reported that the chairman or such other member, as the case may be, ought on any such ground be removed. Clause 2 says, the president in the case of a union commission or a joint commission, and the governor in the case of a state commission may suspend from office the chairman or any member of the commission in respect of whom a reference has been made to the Supreme Court under clause 1 until the president has passed orders and receipt of report of the Supreme Court on such reference. 3 says, notwithstanding anything in clause 1, the president may by order remove from office the chairman or any other member of the Public Service Commission if the chairman or such other member, as the case may be, is adjudged and insolvent or engages during his term of office in any paid employment outside the duties of his office, or is, in the opinion of the president, unfit to continue in office by reason of infirmity of mind or body. Clause 4. If the chairman or any other member of the Public Service Commission is or becomes in any way concerned or interested in any contract or agreement made by or on behalf of the government of India or the government of state, or participates in any way in the profit thereof, or in any benefit or emolument arising therefrom otherwise than as a member of the and in common with the other members of an incorporated company, he shall, for the purposes of clause 1, be deemed to be guilty of misbehavior. So now, my lord, what we find from Article 316 and 317 are, 1, that the appointment of the member or the chairman takes place under Article 316. No qualification is prescribed. Only the term of office is prescribed, and 370, my lord, clearly provides for the manner in which a person once appointed is to be removed. Now, here in our case, my lord, they have recalled the order, firstly on the ground, my lord, legally, firstly on the ground that there was public interest, public demand, and oath of office was not administered. And the question that will arise here is, unless what they have raised here is, unless the oath of office is administered, his appointment doesn't become complete. It remains incomplete. So there is no question of going to Article 317. My submission before your lordship will be, administration of oath of office to the member of the chairman is not there in the Constitution of India. Constitution doesn't provide for oath of office, number one, administration of oath of office. Number two, Constitution also does not say that his appointment under Article 316 is dependent on or subject to further action of administration of oath of office. Well, I am repeating, the Constitution of India nowhere provides that for such appointment to be complete, oath of administration of office, oath of office is to be administered before that. And secondly, it doesn't also say that unless the oath of office or secrecy of office is administered on him, my lord, he doesn't become, or his appointment doesn't become complete. That is my first submission, my lord. Secondly, my lord, if your lordship goes to the regulation, Article 318 of the Constitution provides for the power to make regulation as to the conditions of service of members and staff of the Commission. Lordship will kindly know, Article 318 is very clear. In the case of the Union Commission or a Joint Commission, the President, and in the case of a State Commission, the Governor of the state may by regulations determine the number of members of the Commission and their conditions of service, and make provision with respect to number of members of the staff of the Commission and their conditions of service. 318, my lord, nowhere says that in exercise of power under 318, if anything is required to be done, then unless that is done, the appointment made under Article 316 will not be complete. It doesn't say, my lord. It only says that regulations will be for the purpose of determining the number of members of the Commission and their conditions of service. Once they are in the service, for regulating their conditions of service, some regulation may be made. It also says that make provision with respect to the number of members of the staff of the Commission and their conditions of service, provided that the condition of service of a member of a Public Service Commission shall not be varied to his disadvantage after his appointment. So after his appointment, if any condition of service is made in such a manner that it affects his appointment, that also is not permissible under Article 318. Now, by invoking under Article 318, my lord, the government of Arunachal has, my lord, framed this regulation, which your lordship will find at page 23 of the affidavit in opposition, my lord. It says, my lord, in exercise of powers conferred by proviso to Article 318 of the Constitution of India, the Governor of Arunachal Pradesh is hereby pleased to further amend the Arunachal Pradesh Constitution. Got, my lord, page 23, my lord, I'm reading.
Yes.
Page 23. I'm reading, my lord. In exercise of powers conferred by proviso to Article 318 of the Constitution of India, the Governor of Arunachal Pradesh is hereby pleased to further amend the Arunachal Pradesh Public Service Commission Regulation 1988, namely the Arunachal Pradesh Public Service Commission 9th Amendment Regulation 215, they shall come into force on the date of their publication in the Official Gazette. Insertion of Clause 4A in the Arunachal Pradesh Public Service Commission Regulation 1988, after Clause 4, the following shall be inserted. 4A. The Governor of Arunachal Pradesh or his nominee shall administer the oath of office to the chairman and the members before entering upon their office on the following form, namely so-and-so. So the form is given. Even in the form, my lord, what you will find, I see so-and-so having been appointed as chairman. So appointment is over, appointment is complete. Now, having been thus appointed, I am, my lord, swearing in the name of God that I will bear true faith and allegiance to the solemnly affirm Constitution of India as etc. So his appointment process is complete without this oath. The regulation itself says, Article 316 is very clear. Constitution may nowhere provide that there has to be a ceremony of oath-taking ceremony, and only after that it will be complete. It doesn't provide manner. And so far as the regulation is concerned, my lord, the regulation says the manner in which the oath-taking will take place, what will be the language, and then 4B is there. 4B was subsequently inserted, page 25, Lordship. They have annexed. It says, in the Arunachal Pradesh Public Service Commission Regulation 1988, after clause 4A of the following shall be inserted, the Governor of Arunachal Pradesh or his nominee shall administer the oath of secrecy to the chairman and the members before entering upon their office on the following form. I, so-and-so, having been appointed as chairman. The language is very clear. Having been appointed means you have already been appointed. Appointment is over. Now it is a formality before entering upon office. My lord, here my another submission will be that once the appointment is made, you have, as a government matter, you have no other option but to allow him to start working by undertaking the process of administration of oath of office. In between, you do not have power to cancel the appointment. This Constitution doesn't provide. And most important factor here is, my lord, in the entire affidavit filed by the government, it is nowhere stated that the appointment of the petitioner was illegal. Number one. Number two, it doesn't also say that the parameters on which, because parameters are not laid down in the Constitution, it is the judicial precedence matter which has said that what are the parameters on which a person, because a person cannot be picked up from the street to be appointed to such a office because of the onerous duty to be performed by them. They must have certain credentials, certain qualifications which have been laid down by the Constitution. And I'll go to that later on. But it is very clear that in the affidavit, they do not say, they do not fulfill the parameters even laid down by the Supreme Court. It doesn't say that the selection process was irregular. It doesn't also say that these persons are not fit to be appointed. Unless you say, that is why I said, my lord, in the beginning, going by the stand taken by the state government, my lord, what they have basically said is why they have done it. Yes, there were certain reasons. I understand, my lord, there were certain reasons. But as a state, it is your duty. You cannot say like a private person, see, I wanted to do something, but somebody has objected, so I could not do it. You are not a private person like that. You have the entire authority, full authority to do whatever is required to be done under the law, under the Constitution. Now, if you say that somebody has objected, yes, so far as the objectors, so far as the agitators are concerned, they have every right to object in a democracy. More so when earlier there were some apparent anomalies in the selection process of various posts under the government of Arunachal Pradesh. They have right, and they have rightly done so. They should do it. But the question is, my lord, what they have done is they have objected to the appointment process, the conduct of the FPSC prior to the appointment of the petitioner. And in paper publication, which I have said, my lord, they have no objection as far as the petitioner is concerned. Now, if the stand of the affidavit is such that there are some reasons for which we have done it, and legally, this is the reason we can do it. Now, the question is, this honorable court will test the stand taken by them as to the reasons on which they have done it, whether they could do it legally. If they cannot do it legally, then the exercise of power will be arbitrary. Then automatically the Article 14 will come in, and the honorable court will be entitled to interfere with the decision taken by them. Question is, my lord, you are recalling an appointment of a person on a ground which is not germane to the appointment of that person. This itself shows the grounds on which you have taken the decision are absolutely irrelevant. And that is why it is, my lord, directly hit by the provisions of Article 14 of the Constitution of India, my lord. Now, they say that there were some hesitations. We have decided in a meeting of the cabinet, very well. You should do it. For taking any decision, the matter should be deliberated, matter should go to the cabinet. But the question here is this, as far as your action in recalling or cancelling the appointment of the petitioner is concerned, whether the grounds which you have taken into consideration could be the ground on which an appointment could be cancelled or not. That is the question to be decided by this honorable court. In the entire arbitration matter, there is nothing about the integrity of the petitioner, about the manner in which the appointment process was undertaken and appointment was made.
Is there any parameter for selection?
For
Is there any
selection?
parameter?
Yes, ma'am. On the Supreme Court has said that.
No. Does the government has any parameters of selection?
So far as the government is concerned, in writing there is nothing.
Nothing.
It is a subject to satisfaction. But the Honorable Supreme Court has laid down that, see, you cannot pick up a person from the street. These are the parameters on which you will decide.
What are those parameters?
Well, I'll come to that. Just immediately I'll come. Just before
But
that,
the government, has the government followed it?
they have not said that we have not followed it. And we are not here to go into their record. They have not said that we have not followed. They are absolutely not questioning the selection. They are not questioning the eligibility of the petitioner. They are on a completely different platform. They said there were some objections, and based on it, we have decided. That's all, nothing else. Whether those objections are relatable to the grounds on which a person is appointed, so as to say, let's see, you have to be above 25, but your age is 24. Then they are very much entitled to do it. But that they are not saying. They are saying that there are certain objections. And as far as my advertisement is concerned, my lord, they have given certain requirements with regard to my eligibility. Page 21 of the advertisement, Lordship may kindness, of the writ petition. Page 20 and 20. I have read in the beginning itself, my lord. I'm just pointing out once again since you're on this. Page 25, my lord. The very first paragraph, serial number 1, eligibility criteria they have given.
From where have they prescribed it?
They have, because of the Supreme Court judgments.
Supreme Court judgment. What is the Supreme Court judgment?
Well, I'll just come.
Supreme Court should have, the Supreme Court said that there has to be some parameters of selection.
Yes, on these parameters, a person has to be chosen. Otherwise, anybody cannot be chosen. Supreme Court has said, man.
Okay.
I'll come to that, man. Just I'm pointing out these 2 lines from the page 20. Serial number 1 says eligibility criteria. Persons with outstanding career, outstanding academic excellence, and capacity to judge independently suitability of candidates for a civil post. And then he shall not be a member of parliament, etc. Not required here. Then page 21, minor. 5D in the middle, minor. 5D. Integrity, character, and antecedents. The integrity of the candidates shall be beyond doubt. They shall be free from all types of criminal and other charges. However, the appointment of the selected candidates shall be subject to verification of character and antecedent by the police. On these counts, there is nothing in the affidavit that, see, it was provided in the advertisement like this, you do not possess this.
How they will judge the outstanding career?
It is for them to decide, my lord.
How they will judge the outstanding academic excellence?
And outstanding academic excellence.
And more importantly, the capacity to judge independently. Suitability of candidates.
This they have deliberately put it because their job is to
No,
select
they-
candidates.
Ah,
Now, in
you
what
have put it very nice. It is very nice. But how you get?
my learned friend, learned additional learned advocation will reply to that. Well, my submission before Lordship is that advertisement also, because of the Supreme Court judgments possibly, provides that, see, you must have certain eligibility criteria. And my lord, in order to consider these parameters, presence of these parameters, my lord, page 21A of the petition, we have annexed the notification dated 11th of January 2023, which provides that, my lord. In partial modification of earlier notification dated so and so, the governor of Arunachal Pradesh is pleased to amend the constitution of the screening committee as under for screening the applications received for the post of chairman and members of Arunachal Pradesh Public Service Commission. So a high power screening committee has been constituted, which considers all these parameters. And my lord, one more legal submission they have raised, that section 20, based on section 21 of the General Clause.
The authority who has issued
My lord.
has the power to modify,
Yes,
design.
yes. I'm just reading just 2 lines, my lord. Then I'll go to my submission. Lordship is aware of that. Section 21 of the General Clause says power to issue to include power to add to amend.
General Clauses Act.
General Clause Act.
My copy I have handed over to Mr. Moses.
I'm very sorry, man.
No, we have
We should have had a list.
we have adequate copies, but it's not forthcoming promptly.
It's
That's
my fault, but we should have given a list of books saying that this book is required so that they could keep it training. It's a fault on our part. And this side also, I have a fault because I have borrowed the book from the other side. I have borrowed the book from the other side. Of course, they were quite.
Anyway, you read.
liberal. And I read it slowly. Whereby any central act or regulation, a power to issue notifications, orders, rules, or bylaws is conferred, then that power includes a power exercisable in the like manner and subject to the like sanction and conditions, if any, to add to, amend, vary, or rescind any notifications, orders, rules, or bylaws so issued. So the authority which has a power to do certain things has also the power to undo each matter. That is the basic thing. With regard to this matter, I'll rely on 2 judgments also. My submission is like this matter. Yes, normally an authority who has the power to issue some order, do some act, has also the power to recall the order or to undo it, my lord. But on the Supreme Court says, my lord, if the power is exercised in respect of a particular scheme of things, like the constitution we have here, then it has to be in terms, first it has to be in consonance with the provisions of the scheme and the act. Here, my lord, the appointment was not a notification issued by the government in exercise of its executive power. It is not a that matter. It is an appointment issued in exercise of a specific power under the Constitution of India, that is Article 316. Now, the Honorable Supreme Court says, in such cases where the scheme of things is already provided and the power is exercised in respect of a particular act, then first one has to go to the provisions of that act, which provides for the power to do it and power to undo it. And in that connection, on the basis of that matter, my submission before your lordship will be that when the Constitution has provided for issuing the appointment under Article 316, it has also provided another provision, that is Article 317, to recall that order. Now, if you are to recall that order, you will have to take resort to Article 317 and not in any other manner. And your lordship is well aware, my lord, some court is well aware of the law that from Nazir Ahmed's case, my lord, that if the statute provides, here we have not the statute, but statute's mother, that is the Constitution of India, provides a manner in which a particular thing is to be done. That has to be done in that manner alone, and all other manners of doing it are excluded, my lord. This is what the Honorable Supreme Court is saying in the case of Nazir Ahmed and
Once an appointment order is issued,
my lord.
you become a member of a public service commission.
Yes, my lord. Once an appointment order is issued, the next process which they have is only to administer oath of office because of that regulation. Other than this, they do not have the power to recall it. Their power to recall has to be traced to Article 317 only. And it provides a detailed procedure about the power to recall and remove the person from the office of member of the Public Service Commission.
One become a member of a particular cadre in the service
My lord.
when one joins it.
Yes, absolutely, my lord.
The mere appointment order does not make that person a member of that cadre.
My lord.
There is a joining rule in case of a government servant. Joining rule a condition of service. Joining rules providing for how to join, where to join, etc. Is that a condition of service?
No, not at all. My lord, that is my submission. I'm just
Joining rules is not a part of the condition of service.
my lord, joining procedure prescribed under the regulation cannot.
No.
It's a part of it.
I'm talking of this.
Service jurisprudence.
Yes, government, other employees under the state, not unlike you,
Well.
who is unlike this, which is a constitutional post.
Well.
Joining rules contains a part of the service conditions of the service.
My submission, my respectful submission will be joining rules, if any, does not have bearing on the validity of the appointment order.
No, because
My lord.
question is,
My lord.
see, once the order of appointment is issued,
My lord.
next step is where to join, how to join.
Yes.
But there is a rule.
Well.
Under CCS joining rules or state joining rules. Is that a service condition? Is that a condition of a service of an employee?
My humble submission, it is not. It is not for two reasons, my lord. First of all, the procedure prescribed in respect of service jurisprudence will not apply here for the simple reason that the Honorable Supreme Court has made it very clear that it is not an appointment under the state or under the Union of India.
No, that's correct.
It is a constitutional post.
Th-
Now
That's correct.
my lord.
See, why that question is asked,
My lord.
see, in 318,
My lord.
governor may by regulation determine the number of members of the commission
Yes.
and their conditions of service. That is perhaps the regulation also determines the number of
No.
members, no?
Possibly not. Huh? Number of members. Yeah, yes. Because no, in 4 and 4B it is not there. Otherwise, regulation.
Now, this oath taking which is prescribed therein,
Might.
it assumes importance in the sense that had it not been there, how will you join the office? You have the appointment order. Next step is you have to assume office.
Your lordship is absolutely correct.
So
to the extent of
how you will join the office?
I'll humbly submit my lord. Your lordship is absolutely correct to the extent of saying that yes, without joining office, I can start my work.
Yes.
But question here is not whether without joining I can start my work or not. Question here is what they are trying to take advantage of this, the stage before oath taking is concerned. They are trying to say since oath taking did not take place, we have the power to recall it. Then, my lord,
We are not going to that extent.
my lord, this is their submission.
We are not going to that extent
My lord,
now.
my lord.
See, one has to join somewhere
Yes,
in order to assume office.
my,
Now that is possible by some rules, is not it? There has to be some rules. Like in the case of ordinary government employees, there is a joining rules. So for a constitutional office also, there has to be some rules,
yes, my lord.
whatever it is. You call it a rule or whatever it's called, but there has to be provision for joining, which provides for assuming. And that has been perhaps empowered by this constitution itself to the governor to make a regulation, prescribing numbers as well as the conditions of service. And it is perhaps in exercise of that power, that's oath taking, etc. has been provided. See, your joining will not be in the manner as it is in the case of ordinary government employees, but you will be administered an oath. Thereafter, you will be taken to have assumed the office. Then you become a member of the commission.
Here,
Then you become a member of the commission. Then only 317 will,
here I.
operation of 317
My
will
lord,
begin.
here, my lord, they have taken a stand like this. Here I have got a reservation, my lord. Becoming a member of public service.
Now, just a moment. Now, it is altogether a different matter whether your recalling order was justified or not.
Otherwise.
But to get the protection of 317,
Yes.
perhaps you may have to assume office in whatever form. And the form prescribed here is
My lord,
oath of office, which perhaps is a condition of service, like in the ordinary case of a government employee joining. So unless you are a member of the Public Service Commission, that is why initially I had asked you whether the issuance of appointment order itself makes you a member of the Public Service Commission. Unless you are a member, you become a member, the protection under section 317 will not be available.
May I respond to this? When the concept of becoming a member of service is there in service jurisprudence. Here, my lord, the concept of becoming a member of Public Service Commission is not there at all. This is my first matter. Because my appointment under 316 is complete and is not dependent. I am repeating my lord, initially I made this submission, is not dependent on oath taking. It is true that for starting my work, I have to take oath because it is there in the regulation. As you are not say, there will be some rules. But for not till the time I take oath, they do not have the power to recall it on the ground that I did not take oath. This is my submission. Professor kindly note. I am again repeating.
No, they don't have the power to recall.
No.
Recall.
Yes.
Okay. No.
But there is my submission.
Court is not saying that.
Hello.
Court is saying to the extent of availing the
power
protection under
317. Yes, they have taken it. I have understood. But my submission and my response to this is that first submission is minor. Here, in a matter of appointment to the office of the member of a public service commission minor, the concept of becoming a member of service is not there as it is there in the service jurisprudence. This is my first submission minor. Secondly, my lord, assuming that oath taking is a part of the process by which you start working, does not by itself say that before I take the office or oath, I do not become a member, because there is no question of becoming a member of service. Here it is a constitutional post. Constitution provides for appointment. Appointment has been made. The next stage is removal by under 317. In between, there is no other power, my lord. That is my submission. So, under the regulation, if oath taking is provided, and if oath taking has not taken place, it is the obligation of the state to take it to the stage of oath taking, and in between, for not taking the oath, oath or not administration of the oath, you do not have the power to remove the person by way of recall of the order. And 317 still remains, and 317 power cannot be, the authority cannot be denuded of the power of Article 317. And the power is they are only under 317 and no other power. Between, I'm sorry, madam. Between Article 316 and 317, there is no other stage. As a result, my lord, possibly the government should not forget that only because oath taking has not taken place for this reason or that, and that too in a case of, in the present case, my lord, when the reasons we are citing have got no relevance at all to the manner, to the parameters on which a person is to be appointed. In that case, my lord, these grounds will not give you the authority to recall the order. There is no power under the Constitution to recall the order, my lord. Oath taking, I'm sorry.
No, yes, sir. All right.
My lord, oath taking is necessary for enabling him to enter upon office. But then oath taking again is not a stage which will, my lord, which will, my lord, give the power to the state to cancel the appointment on the ground that oath taking has not taken place. Because, my lord, the appointment under the Constitution doesn't say that it is dependent on oath taking for its validity. Appointment, my lord, of a person as a member or chairman is not dependent on the oath taking for its validity. What they are indirectly saying is, my lord, oath taking, the appointment is incomplete since you have not taken oath. Appointment to be complete, my lord, is required to be an appointment under 316 alone. And 317, my lord, again uses the word only, says the power to remove is only because of misbehavior and the manner of impeachment, etc., provided under Article 317, and in no other manner a person once appointed can be removed from the office of a member. Now, I am repeating my submission that the appointment of a person is not dependent on oath taking for its validity. It remains valid even if oath is not administered. Yes, oath is required, but then oath is not a stage or oath is not a requirement for, in the absence of which the appointment could be valid or the appointment loses its efficacy. Appointment of a person as a member will not lose its efficacy even by an inch for not taking oath. And that cannot be taken recourse to for the purpose of saying that no, now we'll exercise the power of recalling. No, recall itself is a concept which is not provided under the Constitution. They have for the first time introduced a system of recalling. And more so in a case where the reasons on which they have recalled are not at all germane to the appointment, my lord. That is very important. These are apparently, my lord, irrelevant considerations. Have got nothing to do with the appointment of a person.
Yes.
And my lord, one more thing, your lordship will kindly see. So far as the oath taking is concerned, joining is concerned, it is after a person is appointed and it is after a person's appointment is found to be valid. Only then oath taking can take place, not before that. So far as the validity of an appointment is concerned, that is not at all, my lord, subject to the oath taking. Because oath appointment under Article 316 is a complete one, my lord. It doesn't leave anything else to be done by undertaking any other exercise under any other provisions of the Constitution.
What is
because well, just one submission. Because my lord, if we read any other requirement for the purpose of making the appointment complete, that means we are adding something to the provisions of Article 316, which we cannot, which the state cannot. State government cannot add something in Article 316. What they are today saying is action taken by the state under Article 316 is incomplete unless oath taking takes place. That means you are trying to amend the provisions of Article 316.
What is the situation with UPSC?
My lord.
What is the situation with UPSC?
Same man.
Oath taking is there?
Oath taking may be there.
Huh?
Maybe there.
The UPSC also has some regulation of this kind.
Possibly, yes, that I have not examined. With your lordship.
UPSC provision is also here.
Provision is there. Appointment provision is there.
I
I'm
think
talking
it
about the
is
regulation.
similar with the
Maybe
State Public Service
I'm not very
Commission.
sure, my lord. I'll have to look into it. I'll have to look into it.
And the UPSC has some parameters for selection.
Possibly not, my lord. Possibly not. It's like, see, because the judgments which I'll be referring to, they talk about chairman, member, and it's not there.
Okay. But in UPSC, oath is administered. Sure.
My lord, the appointment procedure and the requirement of oath taking or joining as in serviceman is a matter where if the person appointed fails to join, like we have in some service rules manner, if he joins within 15 days, then his seniority will be counted from the date of his appointment as per his position in the merit list. But if he joins after 15 days, then he will become junior to the persons after whom he has joined. So this has got to something to do with his future career. But this doesn't have any bearing on the appointment. Appointment is one thing, future seniority, etc., which are service conditions, is another thing. If he fails to join within the time prescribed as per the joining, then the matter may be different. But here is not a case where our petitioner failed to join or petitioner refused to take oath. Then we are taking this action. So possibly, my lord, I have replied to all the submissions. I'll rely on the judgments. Well, there are only two judgments with regard to the point of the governor having the power to recall. That is on Article 21, madam. Well, I've given a list of books. First, madam, I am relying on this is
To summarize your arguments.
madam, I have finished my argument. Oh, one second, madam. Yes. Madam, my first submission will be that the reasons cited by the respondent government in their affidavit in opposition, for which they have taken the decision to record, are not at all relevant, are not germane to the parameters on the basis of which a person is appointed to the office of member of Public Service Commission.
Is not relevant.
Not relevant and not germane to the parameters on the basis of which a person is appointed.
To the parameters of.
Minor.
Parameters on which
a person is appointed.
Appointed as a member of the Public Service.
Secondly, my lord, the appointment of the petitioner cannot be said to be complete. It cannot be said to be incomplete as alleged, my lord. Incomplete on the ground that he has not taken oath till then, till the order of recall. Because oath, the appointment is not dependent or subject to the oath taking under the regulation.
Yes.
Thirdly, my lord, the appointment of a member or chairman under Article 316 itself is complete in itself, and the Constitution does not lay down two things, my lord. Constitution does not lay down any provision for oath taking, number one. Secondly, my lord, the Constitution doesn't say anywhere that if a person that till the oath taking takes place, the order passed or appointment issued under in exercise of power under Article 316 can be recalled. Meaning thereby, in short, my lord, if Constitution doesn't give them power to recall, particularly in the facts and circumstances of the present case where they are saying that they have the power only because oath taking did not take place, for which according to them, the appointment was incomplete. That is my third submission, my lord. And the submission that before oath taking or before, if you do not take oath, you do not enter upon office. My lord, if your lordship goes to the oath taking provision also, lordship will find that it is only after appointment that oath is administered. Secrecy.
Yes.
So appointment process before the oath is complete.
Yes.
And not dependent on the oath taking ceremony for its validity. Thereafter, next submission is, my lord. After a person is appointed under Article 316, the government doesn't have power to undo the appointment, as they are saying that they have power to undo it. Undo the appointment or cancel the appointment.
Yes.
And for that, the only power available to the government is Article 317.
Yes.
Then next submission, my lord, is that when the Constitution itself provides for a manner in which a person can be removed, that procedure has to be followed, and all other manners of removal of the member of Public Service Commission are excluded. And then with regard to General Clauses Act, my lord, the section 21, my lord, my submission will be broadly, section 21 of the General Clauses Act will not have application, number one. And number two, section 21 of the General Clauses Act cannot be invoked by the government for the purpose of recalling the order of appointment, because in the scheme of the Constitution under which the person was appointed provides for a removal. So by taking recourse to section 21, they cannot remove me. For this, my lord, I am just referring to. Now I can refer to the judgments, my lord.
Section 21 of the General Clauses Act cannot be invoked
My lord.
for recalling of your order of appointment.
Yes.
Because the Constitution itself has provided the provision of removal.
Yes.
And
if
your appointment has to be recalled, it has to be in
done
accordance with the provisions provided in the
370.
370
Right. And
and not under General Clauses Act.
Right. Well, for this section 21, the submission that I have made, yes, 2023 SCC online SC 309, Dr. D.Y. Chandrachud and Hema Kohli, SCC online page 309. Can you listen again? SCC online too. Party नाम तो इसे Odisha Administrative Tribunal Bar Association versus Union of India. ऐसे ना? मतलब I'll furnish a copy of this. I'm just saying. Odisha. Well, I'm reading it slowly. I'll furnish an extra copy of this. I'm sorry.
It is not there.
And my hands now.
Okay. Yes.
Tomorrow morning. I gave a list, possibly that was not available. My lord, para 63, I'm again giving you citation. 2023 SCC online, Supreme Court 309, Odisha Administrative Tribunal.
Yes.
Well, I'm reading a story.
Ah.
Para 63. We clarified that the distinction between quasi-judicial and administrative decisions has been invoked for the purpose of determining whether Section 21 of the General Process Act may be invoked to reverse the decision to establish an SAT, that is State Administrative Tribunal. Administrative tribunal orders continue to be amenable to judicial review in accordance with law. B. Section 21 of the General Process Act is otherwise applicable to the Administrative Tribunals Act. Now, next para. Having decided that there is no threshold bar to the applicability of Section 21 of the General Process Act, we now consider whether it applies in the present case. The locus classicus on the subject is State of Bihar versus D.N. Ganguly, where this court held in para 9 of the judgment matter. It is well settled that this section embodies a rule of construction, and the question whether or not it applies to the provisions of a particular statute would depend on the subject matter, context, and the effect of the relevant provisions of the said statute. In other words, it would be necessary to examine carefully the scheme of the Act, its object, and all its relevant and material provisions before deciding whether, by the application of rule of construction enunciated by Section 21, the appellant's contention is justified that the power to cancel the reference made under Section 10(1) can be said to vest in the appropriate government by necessary implication. If we come to the conclusion that the context and effect of the relevant provisions is repugnant to the application of the said rule of construction, the appellant would not be entitled to invoke the assistance of the said section. We must therefore proceed to examine the relevant provisions of the Act itself. This is number one. Then next parameter, 65. In Kamla Prasad Khaitan versus Union of India, this is a constitutional bench of this court held. Section 21 of the General Process Act embodies a rule of construction, and that rule must have reference to the context and subject matter of the particular statute to which it is being applied. Para 66. Section 21 of the General Process Act can be invoked when its application would not be repugnant to the subject matter, and this is important, would not be repugnant to the subject matter, context, and the effect of statute when it is in harmony with its scheme and object. I pause here for a moment. Now, our constitution provides appointment under Article 316, removal under 317. Now, if they tomorrow pass an order of removal, supposing a person has been appointed, oath has been administered, he started functioning. After 2 years, they say, under Section 21, we have power to recall the order, we recall it. This is what the Supreme Court says you cannot. Because if you are invoking Section 21, you have to first examine whether this is permissible under the statute under which you are working. Here we have got the Constitution under which we have been appointed. Now, Constitution provides a specific manner of removal, that is Article 317. Now, by invoking Section 21, you cannot take away the power conferred by the Parliament under Article 317. This is what the Supreme Court says. Then I go to next paragraph, para 69. As noticed above, the object of Administrative Tribunals Act is to reduce arrears and enable the provisions of speedy justice to litigants. Abolishing an SAT would not frustrate this objective because SATs are not the only method by which the object is capable of being achieved. Further, the effect of such an abolition would not be to deprive litigants of a remedy because of the cases before the SAT would stand revived in the forum in which they were pending prior to the establishment of that SAT. The subject matter and the context of the Administrative Tribunals Act too do not militate against the application of Section 21 of the General Process Act. This is therefore not, there is therefore nothing in the Administrative Tribunals Act which is repugnant to the application of Section 21 of the General Process Act. So, if the application of Section 21 of the General Process Act becomes repugnant to the provisions of the Constitution, particularly Article 316 and 317, then, my lord, this Section 21 cannot be invoked. Well, the second judgment on which I am placing reliance is reported in AIR 1958, Supreme Court 1018. That is it is referred there, my lord, that D.N. Ganguly's judgment, my lord.
1954.
1958, Supreme Court 1018. Just one paragraph I'll read from here, paragraph 9. I possibly need not read. This paragraph has been quoted there. I have already.
Okay.
This paragraph 9 has been quoted. I was trying to read paragraph 9. Possibly I need not read it. That is the judgment relied on in this case.
What was the earlier one?
Earlier one was
SCC?
2023 SCC online.
SCC online.
Then again SC, Supreme Court, SC 309.
309.
Orissa Administrative Tribunal Bar Association versus Union of India.
Okay.
Para, my lord, 63 to 66 and 69.
63 to
66.
66
and 69.
And 69.
My lord. My lord, with regard to the judgment on which, my lord, I was referring to in course of my submissions, which says that although there is nothing in the constitution, but then there are certain parameters are there. For that, my lord, I'll be relying on 2013 volume 5 SCC page 1. 2013 volume 5 SCC page 1, State of Punjab versus Salil Sablok. Para 63, I'm relying. Para 63, 64, 67, 93, 94, and 95.
Yes.
Man. Is an Nikita.
Yes, it is.
63, what you will find at page 42, man.
Yes.
63 paragraph, entire paragraph you can skip because here the article 316 has been quoted. Then para 64, man, this is important. Two features clearly stand out from a bare reading of Article 316 of the Constitution, and these are: one, no qualification has been laid down for the appointment of chairperson of a state public service commission. Theoretically, therefore, the chief minister of a state can recommend to the governor of a state to appoint any person walking on the street as the chairperson of the State Public Service Commission. Two, the chairperson of the State Public Service Commission is provided security of tenure since the term of his office is fixed at 60 years or until the age of 62 years, whichever is earlier. Then paragraph 65, again, quotes Article 317 that we can skip. Then there are 66 lots of mechanisms. Page 43.
Okay.
Page 43, Lord Phil goes.
Page 43, yes.
At the bottom, Lord, you'll find para 66. Lord, she has got.
Yes.
An aspect that clearly stands out from reading of Article 317 is that the chairperson of the State Public Service Commission can be removed from office on the ground of misbehavior only after an inquiry is held by the court on a reference made by the president, and that inquiry results in a report that he or she ought to be removed on such ground. The governor of state is not empowered to remove the chairperson of the State Public Service Commission, even though he or she is the appointing authority. Lord, you kindly know. Even though he or she is the appointing authority. There are, of course, other grounds mentioned in Article 317 of the Constitution, but none of them are of any concern for the purposes of this section. Well, one line, possibly earlier I missed. Here it is very clearly provided that governor of Assam state is not empowered to remove the chairperson of the State Public Service Commission, even though he or she is the appointing authority. That possibly clinches the entire issue. Supreme Court is very clear. Here our order has been passed by the governor. You don't have the power to remove him.
He was already a member of the commission.
Exactly. That your lordship will decide. But I'm not saying.
We are on this whether you are a member of the commission or not.
Yes, lordship will decide.
Yes.
But once your lordship decides that he's a member of service
Yeah.
by virtue of his appointment alone,
Hmm.
then my lord, this particular paragraph 66 of this Salil Sabduk judgment is very clear. You cannot do it.
Yes, yes. Once you are a member, that will be evident from the title of the section 317 itself.
Mine.
Removal and suspension of the member of the Public Service Commission.
Yes.
The issue is whether you can
are a
be
member.
considered as a member or
Yes.
not. Yes.
And then, therefore, my lord, consequentially, the issue which will be more important is whether a person after appointment and before he takes oath can be considered to be appointed or not. Then, my lord, para 67 is of little importance, my lord. A reading of Article 316 and Article 317 of the Constitution makes it clear that to prevent the person working on the street from being appointed as chairperson of a state public service commission, the Constitution has provided that appointment is required to be made by the governor of the state on advice. Additionally, the chairperson has security of tenure to the extent that a person cannot be effortlessly removed from the office even by the president as long as he or she is not guilty of proven misbehavior or is insolvent or doesn't take up any employment or is not bodily or mentally infirm. There is therefore an inbuilt constitutional check on the arbitrary appointment of a chairperson of a state public service commission. The flip side is that if an arbitrary appointment is made, removal of the appointee is difficult process. And this is also important. Assuming that there was some arbitrariness in the appointment, even then you can remove because it's a difficult process. Para 68. If the person walking on the street is appointed in a God forbid kind of situation as the chairperson of the Public Service Commission, what remedy does an aggrieved citizen have? This question arises in a unique backdrop inasmuch as no eligibility criterion has been prescribed for such an appointment and the suitability of a person to hold a post is subjective. This is what I said, it is subjective. Then Lordship may kindly go to para 74 on the right hand side. It cannot be said that the chairperson of the Public Service Commission holds a post in connection with the affairs of the union or the state.
No. You had, now you are reading paragraph 74. You had said you will read 63, 64, 67, 93, 94 and 95. You,
74.
And we had read para
67.
68 also, though you did not say that you will read 68.
I'm sorry, man. Madam, this is 74 is of some importance.
Okay,
I'm sorry. I must say sorry.
74. 68 also included.
69, I have given it.
No, 68. 68, you did not say it earlier.
Madam, now I'm saying.
Okay, 68. Okay.
Then 74, madam. I'm sorry, madam.
Yes.
It happens sometimes.
Yes, why not?
It cannot be said that there are 74, madam. It cannot be said that the chairperson of the Public Service Commission holds a post in connection with the affairs of the union or the state. He or she is not a government servant in the sense of there being a master and servant relationship between the union or the state and the chairperson. In view of the constitutional provisions pertaining to this security of tenure and the removal procedure of the chairperson and members of Public Service Commission, it can only be concluded that he or she holds constitutional post. In this context, reference under Article 317 of the Constitution of India, in Ray, it was held, there are 9 minutes of that judgment. The case of a government servant is subject to the special provisions governed by the law of master servant. But the position in the case of a member of the commission is different. The latter holds a constitutional post and is governed by the special provisions dealing with different aspects of his office, as envisaged by Article 315 to 323 of Chapter 2 of Part 14 of the Constitution. The question of the time. 93. Then those subsequent paragraphs are there where it says that the trustee, etc. And the Meher Singh signing judgment is also referred, which I'll refer separately, and that is why I am not reading this paragraph. The Meher Singh para 78 and 79 this Meher Singh I'll be relying on separately. That is why I am not reading my. Then I'm going to para 93 93, 94, 95. Page 50
Yes.
Having come to a conclusion that an aggrieved citizen has only very limited options available to him or her, is there no redress if any arbitrary appointment is made, such as of the person walking on the street? Before answering this question, it would be worth considering who may be appointed to a constitutional post, such as the chairperson of the Public Service Commission. In Ashok Kumar Yadav versus State of Haryana, this court looked at the appointment of the chairperson and members of Public Service Commission from two different perspectives. Firstly, from the perspective of the requirement to have able administrators in the country, and secondly, from the perspective of the appointment of the institution as requirement of the institution as such. In regard to the first requirement, it was said, para 30, it is absolutely essential that the best and finest talent should be drawn in this administration, and administrative services must be composed of men who are honest, upright. These are the requirements: honest, upright, independent, and who are not swayed by the political winds blowing in the country. The selection of candidates for the administrative services must therefore be made strictly on merits, keeping in view various factors which go to make up a strong, efficient, and people-oriented administrator. This can be achieved only if the chairman and members of Public Service Commission are eminent men possessing a high degree of caliber, competence, and integrity, who would inspire confidence in the public mind about the objectivity and impartiality of the selections to be made by them. Then, in regard to the second requirement, it was said, again, para 30, we would therefore like to strongly impress upon every state government to take care to see that its Public Service Commission is manned by competent, honest, independent persons of outstanding ability, high reputation, who command the confidence of the people and who would not allow themselves to be deflected by any extraneous considerations from discharging their duty by making selection strictly on merit. Para 95. In Ram Ashray Yadav in Ray, this court considered the function and requirement of Public Service Commission and what is expected of its members and held, keeping in line with the high expectations of their office and need to observe absolute integrity and impartiality in the exercise of their powers and duties. The chairman and members of the Public Service Commission are required to be selected on the basis of their merit, ability, and suitability, and they in turn are expected to be models themselves in their functioning. The character and conduct of chairman and members of the commission, like Caesar's wife, must therefore be above board. They occupy a unique place and position and utmost objectivity in the performance of their duties, and integrity and detachment are essential requirements expected from the chairman and members of Public Service Commission.
Now, this paragraph 94, which you have read, wherein the case of Ashok Kumar Yadav has been referred to. And in paragraph 30 thereof, in the second part, it has been said that we would therefore like to strongly impress upon every state government to take care to see that its PSC is manned by competent, honest, and independent persons of outstanding ability and high reputation,
Yes.
who command the confidence of the people and who would not allow themselves to be deflected by any extraneous considerations from discharging their duty of making selections strictly on merit. To pick up this kind of a persons from the applications invited, should the government not have some parameters for selection with an object of selecting a person with the qualities that has been mentioned herein?
Certain things they have given in the advertisement.
But it is given. How that has to be, how whether the particular candidate possess those qualities is to be evaluated or judged by the selection committee, which you have pointed out.
Yes.
How they will make a assessment of the candidate.
I don't know how they do it, I don't know, but they have to do it. Because otherwise they cannot appoint someone. They have to do it. They have to do it. And they have done
So
it.
today we are subject to what they may finally say. It appears that government doesn't have any parameters. Subject to what they finally say. They have appointed chairman and members of the PSC from time to time, and including the stage where you have been appointed. There were no parameters for judging these qualities on a candidate by the selection committee.
In this regard, my submission will be, when the constitution itself has not laid down specifically any qualifications, any parameters, in the advertisement, my lord, they are not required to give everything. They have given certain things because constitution is silent on that. The constitution says you have to pick up a person who will do this job. Almost Supreme Court, having taken note of this fact, has laid down in these 3-4 judgments what are the qualities a person should have. And in this case, in my humble submissions, we are not very much concerned with what are the qualities a person must have, whether they have examined these qualities or not. These are not the question. Question here is slightly different in my humble submission.
No, there's no doubt about it. Now, what the court is trying to say is, during the course of a hearing, we'll ask the government whether there's any parameters or not. Now, because of the judgments rendered by the Supreme Court, though no any standard has been prescribed, though no any parameters have been prescribed under the Constitution, but by interpretation of those provisions, Supreme Court has said that the person manning the PSC must be of these qualities.
That's clear.
Now, to find out a person of these qualities from the applicants, you must have some parameters for judging.
Subjective.
Which is not the issue in this case.
Fine, otherwise no.
Nevertheless, in the course of a hearing, if they don't have any parameters, it is of a great public importance for the people of Arunachal, so that there is a parameter, so that the person with this kind of a quality is picked up on the basis of that parameters, where the assessment is not subjective, it is to a large extent objective.
No, it is subjective. Supreme Court says subjective. Subjective.
Okay, all right. Subjective, but yet you have to have some parameters.
My lord, my submission will be, my lord, although it's not directly in issue here. My lord, the Supreme Court judgments are very clear.
Just a moment, I have not completed
I'm
what
sorry.
what
I'm-
actually I.
I'm-
So given that case, though it is not an issue in your case, in the larger interest of in the larger public interest, for the future days to come also, because Supreme Court has perhaps said that you have to have some parameters of selection. Can this court, though the manner how you have been selected is not at all an issue, can this court go into that issue? Can we ask the government to produce the record on what basis you have selected not only you, others who have not come before this court also, including one chairman who have not before this court. And if you have parameters, all right, you follow that parameters in the future selection also. And if there is no parameters, can this court take some decision in the interest of the larger public interest for the people of Arunachal Pradesh, that the person with this kind of a quality, possessing this quality on the basis of some parameters is also picked up in the future days to come. This is not an issue.
My lord. For
The
future.
query of the court is, can the court go to that extent in your writ petition?
My first response will be like,
We'll ask the AG also,
My,
later part of it.
my submissions in this regard, subject to correction, will be twofold. First is, my lord, so far as the parameters are concerned, there is a screening committee consisting of high officials. It's a high power committee. Now, keeping in view that by now, the Honorable Supreme Court, by the earlier judgment and the subsequent judgment, made it very clear that these are the parameters on which you select a person for this office. There is a screening committee. It is expected that the screening committee members will take into consideration these parameters, and their satisfaction is subjective.
Where is those parameters?
Madam,
Where is those parameters? Nothing is there.
Madam, it is there. It is there, very much there. My lord, the committee members have taken into consideration everything, not only the materials which are produced, they collect inputs, even otherwise. And thereafter.
Today, as of today, you and I don't know.
You
at the court, you are the applicant. You have submitted the biodatas, entire your biodatas,
Yes.
and each of the applicants has submitted. Now, on what basis they have judged the candidates, where 4 of them have selected? It is only known to the government, which government is also yet to disclose in this affidavit, because this is not directly an issue.
Yes.
From the judgment which you have referred to, on reading of it, it appears that though the Constitution does not prescribe any eligibility conditions or the qualities that one should possess, except for providing that 6-year term and 62 until the 62 years. But the Supreme Court has held that there are implied conditions that the members of the chairman to whom you would be appointing should possess these qualities. But these qualities can be gathered from the biodata which you submit, and what process they have undertaken in evaluating the applications submitted to reach to a conclusion that these are the 4 candidates who possess
these qualities.
Who is a competent, honest, and independent persons of outstanding ability and something like that. They have to have some.
And madam, we should also possibly, subject to correction, bear in mind that ultimately a person has to be chosen from the state. Now the best person, of course, the person who doesn't have integrity, he should not be selected. And we cannot say that in the state, by the entire state, we don't have a person who doesn't who possess this kind of qualities. So accordingly, the petitioner was appointed.
All right, we proceed.
My lord.
Because man on the street,
Cannot be.
if he is competent, honest, and independent persons of outstanding ability and high reputation, if he is as a 25 years also can be picked up. Unless there is some, yes, they have some parameters. You can't say that the person of a 25 years cannot be honest, competent.
No, possibly 25 years I can prevent by saying.
And it will, and it is on the basis of your argument only. Nothing is prescribed in the constitution.
Constitution matter.
Yes.
And Supreme Court also says there is nothing in the constitution matter.
As has also some relevance
Right.
for attaining these qualities mentioned by the Supreme Court. But can we say that no, there cannot be any minimum age, implied minimum age for appointing a person as chairman or the members? It might so happen that all members are of 55 plus age, and the chairman is of 28 years.
No, if you lordship goes strictly
There has to be some parameters by the government.
in the Ashok Kumar Yadav,
And thereafter, when the case is brought to the court, and the counsel like you defending the chairman as a 28 years will argue, nothing is there prescribed in the constitution.
no, possibly, my lord, that is why it says, my lord, lordship kindly see. I'm just reading once again. This can be achieved only if the chairman and members of the Public Service Commission are eminent man. At the age of 28, nobody will form an opinion that a person of 28 or 25 or maybe 30 has acquired that eminence in the society that he should be appointed to this office. And it says, my lord, eminent man possessing a high degree of caliber, competence at the age of 25. What competence will he have? What experience does he have in life? Master degree at best. So at the age of 28,
Degree is not the.
Sachin Tendulkar acquired eminence at the age of 21.
So therefore, in this background, I am again repeating, these queries are not for any other purpose.
I have understood.
This is for the purpose that
Future.
yes, taking these factors into question,
Can the
though this is not the issue here, can this court under 226 go to that extent of asking the government what parameters you have followed, and show us the record on what basis you have made these selections?
Well, possibly the PIL which has been filed has got directly this issue.
PIL will not report this court.
No,
Query
this
is,
is the issue in the PIL. But in the PIL, the issue is.
see, PIL will take it up when it comes to.
I'm just saying, man. I'm not
No,
saying.
you, on the one hand, referring to the Dwarkanath case, says that the 226 power can go to any extent,
Right.
even if the issue is not directly involved. If during the course of the hearings and the pleadings, if it comes to the, if it comes to the notice of the court,
Right.
that there are some injustice going on, which has, wherever it is, which is to be corrected. In that background, can this court go into how you, four of you have been selected? If they can show some basis known to the law, not necessarily very objective, we put a lid on this matter. But if not, can we give further directions? Again, 226, in the larger public interest for the people of Arunachal Pradesh, because you will be intermittently appointing chairman.
Yes.
And is noted without any parameters. This is the query I'm repeating. It. We'll ask the Advocate General also when this term comes. The
And
query is,
his-
can we go into?
And his immediate reply is at the age of 21 also. If a person like Tendulkar can acquire the expertise in cricket.
So if you say yes in the larger interest of the public, even if it is not issue directly involved in the case, this court is competent to go into that. Then we may explore the possibilities in that line also. But if you say that no, this court can't, then we will not go into it. Yes.
For that, I'll have to think once.
See, this is a larger interest. Today you are fighting for your office. Justified. But what is the basis? Because until you had produced this judgment and maybe some more, we didn't know that, is not it? There are some implied requirements, though nothing is prescribed therein in the constitution. So, but they will have to have it, some kind of parameters. So, otherwise, repeatedly it has been used by the Honorable Supreme Court, man on the street can be, huh?
The Supreme Court has on the one hand expressed the apprehension that man on the street should not be appointed.
That is why.
At the same time, in the same tone, my lord has further said that these are the qualities which a man on the street cannot ever have. So therefore, unless these qualities are there in a person, he should not be appointed as a member or a chair. So my first response will be, my lord, if the parameters are already laid down by the Honorable Supreme Court, the authorities should follow it and then go ahead. Further exercise, possibly is my humble submission probably required, because it is already there. Supreme Court has taken care of it, that these are not there in the Constitution. Therefore, Supreme Court has ventured into it and said that yes, these are the qualities one must have before he is appointed to a high office.
But how the selection committee will judge that this
Selection committee, how they will do it, possibly it is for them to decide.
that is what
Lordship may ask them.
so we'll ask them.
How you will do it.
The question to you is
Whether this court should go in.
since this is the petitioner may not be interested in that.
I as a counsel.
Is not it? But can this court, will this court have the power to go into that? In the facts and situation, the facts and circumstances of this case, though it is never the issue directly involved in this case.
I don't know, my lord, but then my submission will be that this should be left to the discretion of the selecting authority, committee, and the government. Because governor also will act on the aid and advice.
If you leave entirely to them, they will have the discretion to recall also.
No.
You can't leave entirely to them.
No, well,
Largely it is them.
the screening part, my lord, the screening committee
Yes.
that they have. I'm not talking about the screening part. That part should be left to the discretion of the authority.
No, we'll ask him when his turn comes. Perhaps in this case, Punjab and Haryana High Court had given direction to the government to frame guidelines. That was
In this case,
Ah.
the case at hand, which has been placed by my
Ah,
learned friend,
ah.
Punjab and Haryana High Court had laid down the parameters.
Okay, laid down the parameters,
So
yes.
that went up to Supreme Court.
Yes, sir.
Supreme Court said that High Court does not have the power to do it.
Yeah.
But it
Government
is
should.
desirable, it is desirable that the state does it.
Yes, state does have. So why the state of AP should not have some guidelines? Otherwise, if we don't do it today, it will be a lost opportunity. Government will never have these guidelines. Is not it? So this is an opportunity for the people of the state.
They should take this opportunity.
No, you as a citizen will also will have to render assistance
Fine.
in the larger interest of the public,
Fine.
though it is not an issue involved in the writ petition, where you are entirely defending your appointment.
Well, this para 154 of the judgment itself says, given the experience in the making of such appointments,
Which 154?
this series of the 2013 5 assessment,
Okay, 154.
155.
We are actually in paragraph 94.
Yes,
Something like that.
I'm now reading para 1, last paragraph, last part 1, was para 154.
But 95 also you wanted to read? Okay, 154.
The 95 I have read, madam.
Okay.
I have read. 153 and 154, last page, madam, page 67.
Yes.
153 says, in the view that I have taken, there is a need for a word of caution to the High Court. There is a likelihood of comparable challenges being made by trigger-happy litigants to appointments made to constitutional positions where no eligibility criterion or procedure has been laid down. The High Courts will do well to be extremely circumspect in even entertaining such petitions.
That's why we are, today also we are circumspect. We are asking you, can we go into that?
It is necessary to keep in mind that different elbow room must be given to the executive, sufficient elbow room to the executive to make constitutional appointments as long as the constitutional, functional and institutional requirements are met and the appointments are in conformity with the indicators given by this board from time to time. Given the experience in the making of such appointment, there is no doubt that until the state legislature enacts an appropriate law, the state of Punjab must step in and take urgent steps to frame a memorandum of procedure and administrative guidelines for the selection and appointment of chairperson and members of Public Service Commission, so that the possibility of arbitrary appointments is eliminated.
Yes, this is it. This paragraph 153 is for this court cautionary note to the High Court that after this guidelines, administrative guidelines is framed by the government and appointment is made thereafter, there may be petitions challenging those appointments on the basis of this court has to be very circumspect and must not intervene so readily and should leave much of the elbow room for this thing. But 154, they must have guideline. I don't think you have a guideline.
But I'll have to take this time. Even I doubt. And I have been told, my lord, I've just been informed that precisely on this issue, a PIL apparently has been filed saying that there should be guidelines. So that issue has already been here. If your lordship goes into it, the issue per se will not be part of the pleadings, but there it is directly.
I am also aware of that because I was present on the day when PI was moved.
But that will be for the future guidelines.
Future guidelines. Yes.
Okay.
Future
Not
guidelines.
in the
This is what your lordship is possibly thinking, that for future they must have a guideline.
here also.
Yes. That is what
Here also.
Yes.
Since you have not even assumed the office, here also, perhaps this may have some relevance. May not be in strict sense, but in recalling of the something like that. Though it is not at all their case. That it is for their case is entirely different. Yes. So this decision you had relied on was for the proposition?
Which one, my lord?
2013, this case in
13,
hand.
my lord, I have read it for the purpose of saying that who can be appointed and the parameters which are there.
And you had para 74 you had referred to content that
74 to content that governor cannot do it.
Governor cannot remove. Removal is only
317.
371 something like. Yes.
Continue possibly.
But nobody is coming.
No, now.
I was waiting. No.
When do we argue next? Tomorrow, I got some difficulty. I expressed in the beginning. Lordship may keep it partner, then Lordship may take it in a subsidiary.
The part
My
of,
friend is also there in a connected matter, identical challenge.
Yes.
He can complete his arguments tomorrow. And maybe I can, if possible, I can also conclude. Then we can perhaps give a reply on some other day.
no, have you concluded your argument?
I have not completed. There are 2-3 more judgments I have to cite.
He has to complete first. Partner is not advisable.
Difficulties when tomorrow the matter is people almost chief justice when that is the together. So I could have taken, I could make some arrangement.
Our problem is, my lord, we are functioning without a commission altogether.
I mean, in fact,
Because what had happened was, they took the matter to the division bench. There an interim order was passed, staying the advertisement itself. We have sought for a clarification by filing an IA. In the IA, the division bench has allowed us to proceed so far as one post of chairman and one member is concerned. But that also has been, we have been asked not to finalize it. So, my lord, what has happened is essentially we are without a commission, and none of the selections are being naturally conducted. The Public Service Commission.
All right, tomorrow we'll hear Mr. Panging and Mr. Advocate General.
That can be done. Otherwise,
And we'll accommodate you sometime in the next week.
my lord, next week.
I can come back next Monday if necessary. This case has utmost priority.
So you keep the record also ready.
So far as this selection is.
Yes. Let us see.
Good.
What is,
Just
you have heard what the query was. And both of you should render assistance in this case.
True, man.
If this court can go into them.
True.
Otherwise, see, they will not have the
now it
guidelines.
has come to my notice one of this aspect. I will also pursue it.
No, we have complete faith
My
in you.
learned friend utilize his office, good office for this. This will be example for future. As an AG, my lord, you can always.
In fact, my lord, immediately after this, I'll be attending a meeting with some very high functionaries. I can raise the issue today. And it is for the betterment of the state. For all future selections, it will be.
Okay, all right. So we continue tomorrow?
Yes.
Let's do tomorrow. Okay, just.
I think my friend Mr. Panging will also take some time. I will also need some time. Can it be immediately after the motions? That way we can at least try and finish off our part.
Okay, we'll try. Okay, we'll see it tomorrow.
Yes.
Madam.
How does the counsel for the petitioner in WPC 2023 of AP 2023, which remain inconclusive.
Yes.
Please vote the writ petition. As provided on the council for the parties, please sit tomorrow, give the date.
Well, this 7 for my part matters. On 17th, can I fix it?
17.
17.
Okay.
Is it Thursday?
Let us see tomorrow.
If necessary, because 17th,
case
if I can complete, I can stay back up to 18th also. So both the days I can.
Okay, tomorrow we'll try to fix it on 17.
I'm just indicating so that.
Indicating.
17 the other particles. All right. 16.
No, that will fix.
Tomorrow we'll try.
Tomorrow we'll sort it out.
What are the